tomorrow in motion. I filed it day before yesterday, and he is already 16 days in custody.
No,
So
no.
kindly allow me to list it
This
tomorrow.
is not the bailments.
Oh, sorry.
Maybe, Your Lordship, I had mentioned on item yesterday for listing. It has been listed. But what has happened by act of fate, my lord, it has been listed before Justice Mojumdar. But the issue I was bringing in, Rajesh Mojumdar is intricately connected with it, my lord. Some other bench may be allotted, my lord. This is my prayer. Tomorrow, my lord. Today is not possible.
Make a mention memo,
Yes, I'll file a mention memo.
because I cannot pass that order.
My lord.
That court has to be,
Yes,
that
as
court
we
has to
have,
pass an
my
order.
lord, as I am mentioning here, it is being done in that court also. Obligation.
May it please, Your Lordship. I beg to mention one criminal revision petition, my lord. My lord, it was supposed to list after.
New or old?
My lord, actually, it is.
Yes,
it is
new or
taking-
old?
My lord, it was filed in July, my lord.
Fresh or?
Fresh motion, no, my lord, fresh
No,
motion.
no. Not
My lord, problem is that.
immediately after vacation. No,
Pleasure, Lordship.
old matter.
Lordship, I beg to mention item number 25, maybe.
Item number
Item number 25.
25.
5. Maybe adjourn for today, Lordship. Admission matter, Lordship.
Okay. On the prayer of Mr.
A.K. Hendrik, Lordship.
A.K. Hendrik, Learned Counsel for the petition. Appellant release the case on by the board.
Your date may be fixed, Lordship. After
21st.
May I
Yes,
please,
sir.
Your Lordship, I wish to mention item number 9, my lord.
9.
And motion matter, in this case, we have to file additional affidavit, my lord, so
Oh.
matter may be after vacation.
Okay, Mr. H.A. Ahmed, Learned Counsel for the petitioners has submitted that the petitioners, has submitted that an additional affidavit is required to be filed in this criminal petition, and he has sought listing of the case on some matter.
9-1.
Publish.
List the case accordingly on so and so.
Lordship, beg to mention item number 13. Oh, motion.
1-3.
Yes.
Yes.
Our senior is actually Ali.
On the prayer of Mr.
And Ali.
and Ali, Learned Counsel for the petitioner.
On
List the
behalf of
case on
Pierre
so and so
Babu.
date.
May it please, Lordship. Lordship,
19.
Lordship, I beg to mention one IA criminal for listing.
I
Criminal for listing.
criminal for what?
Lordship, condemnation of DA.
Okay.
May I please, Your Lordship, I beg to mention item number 3. My lord, it may be come on after vacation, my lord. Mr. B. Choudhury is out of station.
Okay. On the prayer of Mr.
F.A. Hassan on
F.A.
behalf.
Hassan, Learned Counsel, on behalf of Mr. B. Choudhury, Learned Counsel for the petitioner, list the case on so and so.
7-1.
7-1. My lord, one more prayer, my lord. A criminal petition, my lord. NBW was issued against me, my lord. Motion matter, my lord. Come on tomorrow, my lord. Please, my lord.
May I please, Your Lordship. Lordship, I beg to mention one IA in criminal petition. Lordship,
IA in criminal petition for what?
Lordship. Or interim's order, Lordship.
After
in the-
vacation, after vacation.
Lordship, can it be tomorrow?
After vacation.
Lordship, there is an urgency, so
After vacation. Already moved the criminal petition, right? Next.
Daily list for motion. Item number 1.
May I please, Your Lordship. Lordship, this petition move against the rejection of Jimma pair for the
Hmm.
petitioner. And the last occasion report was called for.
Yes, Mr.
My
Goswami.
report,
gone
my
to
lord,
the
my lord,
case
TCR call for, my lord.
TCR received. Have you gone
Yes,
to the
sir,
case
yes.
record?
My lord, I have not gone through the entire TCR, but from the search sheet, my lord,
Hmm.
he is not search sheeted.
Hmm.
That is what I have seen, man. But I have to check all.
See,
Yes.
take it up on 5th of January. PP Dr. of Learned Counsel for the petitioner is present. Mr. MP Goswami, Learned Counsel for the Learned Additional Public Prosecutor, has sought listing of the case on 5/1/2026 in order to go through the TCR.
Yes,
Release the case accordingly on 5/1/2026. You look at it
yes, and there are
today
certain-
only.
yes, my lord. My lord,
Don't take
cer-
time.
certain parameters are laid down, my lord, who is eligible for getting the vehicle, my lord.
One is that.
Yes, and judgment
Find
is,
out some cavities or
or yes,
secret chambers and
Yes,
how many
yes.
kgs?
No, that 337 kg Lordship by the driver.
Only,
by the driver, my lord. Only
Commercial
only.
quantity,
We have
but
to
So
show-
this cannot be, if it is found in a secret chamber or something like that,
it is
it
diverse.
cannot be without the knowledge of the owner.
Yes, that
That
part is there.
Vishwajit Dev
That is why-
judgment.
May not be, Biswajit, it is only 4 situations laid down.
Yes,
No,
That
sir.
is not exhaustive.
yes, yes,
Yes.
not exhaustive, but however, but from,
The quantity is important.
My lord.
but rule of the petitioner is not there, cannot be attributed by the police even after.
Let us see the construction of the truck.
Yes,
Truck,
truck, 12 wheeler truck.
if it is
Contraband
suppose
was
300 kgs
Contraband was
are kept inside a secret chamber,
of the driver's cabin,
huh?
driver's cabin,
Secret chamber.
yes.
Secret chamber. Find out
Driver-
what kind of secret chamber.
That too by,
Owner without knowledge,
no, that my number plate of my vehicle was also fake, Lordship.
go this way or may go against it. Let us have.
Anyway, Lordship, what I did.
You also look at it.
Item 2.
May please, Your Lordship.
The respondent filed petition and not venture against the petition is filed. You have to hear in the final order. If you get a date of filing on. Yes,
It's a notice may go, Your Lordship, there is a
only notice,
proceed-
nothing else.
procedural lapse.
4,000.
Procedural lapse also there in this case, Your Lordship, there is procedural lapse.
Left will not see.
Your Lordship.
Affirmed by the appellate court.
Lordship, there is a procedural
And
lapse.
Mr.
also.
S. Islam and counsel for the petitioner. First of, agreed by an order, judgment dated 16/9/2025. Passed by the Court of Learned Additional Session Judge Bizni in criminal revision within bracket appeal number 03/2025. The petitioner is before this court. Full stop. By the judgment dated 16/9/2025, the revisional court affirmed
Your Lordship, appellate court. It should be
No.
appealed. In DP case, appealed.
criminal revision again.
They
This is
have-
confusing.
They have falsely.
The Court of Learned Additional Session Judge, Bizni, cannot be revision and appeal together.
No, Your Lordship, it is a appeal, that but wrongly quoted as revision, there is a
Whatever.
court interpret that it should. be-
Whatever. As affirmed, a final order dated 18/11/2024, passed by the Court of Learned Judicial Magistrate, First Class, Bizni, in CR within bracket DV bracket of case number 86/2023. So, by the final order, the petitioner has been directed to pay a maintenance amount of rupees 4,000 per month from the date of filing of the petition by the respondent under section 12 of the Protection of Women from Domestic Violence Act 2005. Full stop. In addition, the petition has been directed to pay an amount of rupees, a sum of rupees 10,000 as one-time compensation. Issue notice returnable on so and so. Steps. Speed post, 2 working days.
3001. 30.
Bless.
Item 4.
Today is fasting. Okay,
A notice will go only.
notice will go, notice.
My lord, we have solved,
Listen.
there is an interim protection we got in ancillary bill we moved in respect of the second FIR, we have been protected.
Thank you.
We are saying that our whole case is that it is a test of sameness.
Need to wait for.
Same
42.
FIR, the subject matter being the same in the second FIR. So we got some interim protection from this honorable court by way of AB. Here we have come for questioning of the second FIR. only at the, I will show your lordship.
Where is the second FIR?
Yes. If your lordship is not inconvenient, my lord, can your lordship goes to the first FIR? I have to show. No, no. My lord, if your lordship goes into page 27,
Page 27.
27, if your lordship looks into 27, date kindly see on the first one, New Delhi, so and so, RC 217-2025-80012. Lordship got it? Dated is 3/5/2025. And the number 2 PC Act 791012 and section 61(2) of the BNSS.
That is
Please.
61 to
61(2) criminal conspiracy. Now, Lordship, please look into the place of occurrence at serial number 5, Noida, UP and Dibrugarh, Assam. Lordship got it? At
Yes.
4, 5. Now,
Yes.
my lord will see the complaint. Complaint is 3, kindly see at page 32, my lord.
Hmm.
32. Source of information also reveals that on 18/4/2025, see Jyoti Kumar Singh, he is accused number 3, my lord, and he is a DGM sales
Page 32.
32
Hmm.
is the source information.
Hmm.
See, please, 3, my lord.
Yes.
Source information, para 3 also reveals that 18/4/2025, the Jyoti Kumar Singh conveyed to see Prayat Chakraborty. I'll just tell your lordship this.
What is the first para?
I'm sorry, first.
First para.
Oh, why? Source information revealed that the Prayat Chakraborty, Deputy General Manager, Oil India, Duliajan, Assam in connivance, which is Jyoti Kumar Singh, DGM, Sales and Marketing of Messrs. United Drilling Tools, Noida, an unknown public servant are indulging in corrupt and illegal activities of obtaining bribe money, again facilitating the issuance of award of work and clearance of bills of the said against soliciting the issuance of work and clearance of bill of the said private contractors, supplier, thereby causing huge wrongful gain to themselves, corresponding wrongful loss to the union exchequer. 2. Source info further revealed that on 16/4/2025, Sri Priyaj Chakraborty again demanded 17 grams of gold ornament for himself as well as for some other unknown public servant from the Jyoti Kumar Singh against award of certain contract in favor of him. And Sri Jyoti Kumar Singh also agreed to a demand. Number 3. Source information revealed that 18/4/2025, Sri Jyoti Kumar Singh conveyed to Sri Priya Chakraborty that he has taken the approval of his managing director Sri Kunal Gupta for a bribe amount of rupees 7 lakhs. Sri Priya Chakraborty reminded him that he has not asked for cash and once again demanded delivery of 70 grams of gold coin instead. Sri Jyoti Kumar Singh also told him that due to some reason he won't be able to purchase gold and therefore he would deliver rupees 7 lakhs in cash instead. 4 sources inform exists that on 3/5/2020 evening, Jyoti Kumar Singh would be delivered certain cash amount as bribe instead of gold to see Priya Chakraborty near sector so and so, which is also close to resident of Sri Priya Chakraborty at Noida. The above mentioned act of public servant, private person disclosed the omission of cognizable offence under section 61(2) and 7, 9, 10, 11 of PC Act. Hence, a regular case registered against Sri Priya Chakraborty, DGM Oil India Limited, Central Public Sector Undertaking of so and so, Kunal Gupta, Managing Director of United Drilling Tools. Number 3, Jyoti Kumar Singh, DGM Sales and Marketing of United Drilling so and so. And 4, United Drilling Tools Limited and unknown person or private person investigation of the case. I am not this person, unknown. Now, my lord, why I came to in the first FIR? Because of a seizure. They have seized. They came to my residence and the office at page 33. Kindly see, my lord. Page 33. If your lordship looks into it, page 33 and see the first name of the so-and-so branch, criminal so-and-so, number 2, see the resident premises of Tusar, lordship got it on the right hand side, Tusar Kesha so-and-so. So these are petitioner before this court. Now name so-and-so, kindly see, my lord, what was recovered at serial number 1 down below, Description of article seized, one invoice dated so and so of 10,300 issued by so and so. Now, this is the, now if your lordship looks into it, the seizure, so far as the commercial place is concerned, this is important, my lord, at page 37. Now, if your lordship looks into page 38, see the file number, file GM, tender number GM 2024, dated 7/6/2024. Lordship, please note this, because this is a subject matter in the second FIR, which they have, my lord, they seized this file. Now, this matter was moved before this honorable court because when they came to my residence for search and seizure, I came to this honorable court by way of an AB 52, kindly see, my lord. 52, my lord.
Yes.
Lordship got it?
Hmm.
52. This is, see para 5, my lord. It is submitted, annexes is a search list, and while searching a file number, GM dated so and so was seized along with other article. The search list also contains so and so, so and so. Now, please turn to page 55, my lord. 55. Meanwhile, in the interim, in the event of arrest, the petitioner shall be enlarged on bail and they shall appear before the so and so. One, cooperate with the investigation, appear before IO on every fortnight, and which we comply. And thereafter, my lord, interim bail at page 56. Certain, they have sought for to produce certain documents at page 56 under 94 of the BNSS. See the list
Hmm.
which they have sought. Accordingly, we have submitted at page 58. 58 we have submitted. And at page 61, we submitted at page 58, my lord. They have received. And at page 61, the interim bail was made absolute on 26/8/2025. Now, I'll show one thing before this court, my lord. While the first FIR, when we moved, my lord, my learned friend, CBI representing, they were given a chance to file an affidavit before the court. And accordingly, affidavit was filed at page 64. Thereafter, the matter was considered. See page 64. At page 64 is the affidavit of the CBI. Which at 65, lordship got it. Now, kindly see 67, my lord, paragraph 7. 7. That interrogation of accused Priya Chakra further revealed that he had received 2 gold chains from petitioner Tushar Kasra. This is the petitioner, my lord. Proprietor of so and so on 12/4/2025 as illegal gratification for favoring the said firm in awarding a tender worth ₹3 crores for supply of genset. He admitted to having processed the contract, which was awarded during March 2025. The said 2 gold chains have also been recovered and seized. So this is in their affidavit, they have brought this before this court. And after that, my lord, the matter was considered by the court at page 61 on 26/8/2025, my lord.
Yes.
At page 61,
Hmm.
my lord will kindly see at 62, my lord, paragraph 3. It is submitted by so and so learned standing on CBI that charge sheet has already been submitted in this case, wherein the present petitioner has not made an accused, thereby indicating that no sufficient material has been found during the investigation against the present petitioner. Now that lordship bill 63, that interim bail was made absolute. Now, when it was made absolute, my lord, they again lodged a second FIR, which is before this court, and accordingly I have been protected. Now see page 43, my lord. This is the second FIR.
Yes.
And kindly see one serial number 1. This is RC 21/17/2025 A0019. It was 12, now 19, and dated is 18/8/2021. Earlier was 3/5/2025. Please see, my lord, the sections are same. 5, kindly see 5, below 5, serial number 5 at page 43. Place of occurrence, Tinsukia, Assam and other places. Now, Lordship will kindly turn to 44. 44, number 2. Now here they make me an accused, Tushar Keshra. At serial number 72, my lord, 72. Lordship got it, my lord.
Yes.
Now, the second FIR is a complaint, is at page 46.
Yes.
Now, kindly see, my lord, case so and so 33.5, Lordship on the top. Under section so and so, as registered by CBI on source against the prior Deputy General Manager on limited. So during the investigation, trap was laid by CBI on 3/5/2025. During the trap proceedings, Sri Jyoti Kumar Singh, Deputy General Manager. United-
So, in the course of investigation of first FIR,
Yes.
a trap was laid.
Yes,
Trap was laid.
papers late. Trappers not late, again the officers and again those United will, where they wanted to
Yes.
pay
yes,
certain
I
amount.
understand.
Now, so and so, the said bribe was paid so and so, as his company United was awarded a contract of so and so of rupees 13.73 crore, which is in which Priyacharu was accused in purchase officer. Investigation so and New Delhi has revealed Priyacharu has joined Oil India so and so. Recently, Priyacharu has been working as Deputy General Manager. They were seen 35/2024 after completion of deputation in Directorate General of so and so. After his deputation, Priyacharu was assigned the works of table number 8 at Material Department so and so. However, by order, he was assigned the works of table number 9 on transfer of so and so. The then DGM material purchase from Material Department to Project Department was suspended from the service on 4/5/2000, passed after registration of case against him. Now, this 3 is important. During interrogation, in presence of independent Prayat Chakraborty and revealed, he had received 2 gold chains from Tushar Keshra on so and so on 12/4/2025 at Tinsukia as illegal gratification favoring the firm, namely Messrs. Industrial Trade and agency owned by Pradeep Kumar Keshra against tender worth rupees 3 crores for supply of genset awarded so and so. Prayat Chakraborty has processed the said contract. Said 2 gold chain be recovered and seized by CBI on 3/5/2000, which is the first subject matter, mile. In presence of Priyacharu, independent witness. Now, second mile. Investigation revealed after due approval of competent authority, mobile number of certain others were intercepted. The recorded intercepted conversation held between Priyat Chakraborty and Tushar Keshra, as well as other document collected in investigation, primacy established that Priyat Chakraborty demanded illegal gratification bribe from so and so in lieu of tender numbers dated GM 2024 B50219000, which your lordship will find at page 38, my lord. At page 38. That's the same file which has been seized so for interrogation in the first FIR is concerned. Awarded to industrial so and so. Priyat Chakraborty was the purchase officer. Tushar has paid the said illegal gratification in form of 2 gold chains. My lord, this is the whole subject matter of the case, my lord.
So far, that GEM case file number.
Yes.
File number.
Yes.
Which was seized
Yes.
when a search was made.
Yeah, correct, my lord. At page 38, my lord.
Page 38.
Eight. At
Page
first
38.
FIR, when it was seized,
8.
as page 38, serial number 1, my lord.
Whether in that file, this United Drilling Tools were involved?
No,
No. Okay.
that's what my, now only a notice will go at this. I'm not asking,
My humble submission before your lordship. In this case, Tushar Kasera has taken anticipatory bail in the first FIR. His name was not there in the first FIR. And first FIR is arising out of a trap of the Prayas, who is the public servant. And that trap has been done at Noida. Jurisdiction fall under the Ghaziabad special judge. While filing here, an anticipatory bail, we have given an objection that jurisdiction won't lie, and moreover, he is not the named accused person. That is in FIR, first FIR.
Ultimately, charge sheet has been submitted.
But
He
in
was not named as an accused.
accused
Yes,
in first
something-
FIR.
Something was revealed.
However,
Ah.
kindly, I may be submitted. However, during the course of investigation, because both of the company are the contractor of the IOC, Indian Oil Corporation. So when during the course of investigation, it is found some incriminating document from the house of the Tushar Kasera. However, since his name is not there and he has obtained the anticipatory bail without having the name in the FIR, that matter is closed against him and the final report has been filed. I am going to file objection in that anticipatory bail. So this matter is there over. Only two accused person, I am coming to that. So
This
the
Proya Singh-
assertion
petition-
that two FIR is that it is totally wrong assertion. Reason being, in the second FIR, when during the course of investigation, gold chains are revealed, it has come from the mouth of the Tushar Kasera that he has given a 2 gold chain, as well as it has come from the mouth of the Prayas that he has also received 2 gold chains from Tushar Kasera. In view of the larger conspiracy, CBI started doing the investigation. During the course of investigation, when it has come to the knowledge that 2 gold chain has been given to the public servant, they have filed another FIR, that is 19. For your lordship convenience, we have prepared one
We are
reply
issuing
for
notice at this stage. We are issuing notice at this stage.
this stage. I don't think there is any merit in this case because total in both the FIR, in one it is a United and in another it is industrial.
Raise
So-
your version, in writing.
As your lordship pleases.
Investigation will
But
go
it is not 2 FIR. It is a separate FIR, separate transaction. One is arising out of trap, another is arising out here at in the Dibrugarh Jorhat, I think, Tinsukia.
I have understood substance of
And-
submission of both the parties.
I have one case law that when they have preferred a application for anticipatory bail, at the same time parallelly, the quashing cannot be filed, criminal quashing, criminal revision.
Hmm.
I have gone through.
Whether they have preferred any AB in
Yes,
19.
yes, in 19 they have preferred. Today we are going to file a reply. This is
Okay.
the reply for 19.
He has received interim protection.
Yes, he has already received an interim
Okay, you file
protection.
your objection, then if it is not maintainable, not maintainable.
And at the same time, this
And
criminal- and at
just
the
on
same
the
time,
brink
this
of
criminal petition
vacation,
is
it is
also there.
difficult to, because
It is not maintainable in view of the filing of the.
you file your objection immediately after vacation, we'll take up
But no,
6
state-
or 7.
But no.
No, we are not going.
I'm.
That he has, at the first point of time, he has said.
Here,
So that is why I am trying to curtail.
Much obliged. Your
First,
Lordship.
argument was that there is no stay, I'm asking.
Ah.
You should hear it.
Submission was that. That is why I have said.
But
कि
prima
once
facie it is not maintainable
Huh?
when AV is.
You show your prima facie that you have found the incriminating materials in the second one. They will make submission that this is a continuation of the first affair.
But their.
So second FIR is not.
2 FIR, this is a totally wrong submission.
I have understood.
With all due respect, I have
Miss-
submitted.
Seeing I have understood their submission, your submissions also. Briefly, I have understood, not totally. Because on this aspect, I had to argue before a court for 1 year, 40 hearings I had done, first FIR, second FIR. So at least I have brief idea.
But this is not
After
that.
exhausting Indian laws, I had to resort to English laws and American laws.
But with all respect to
Ultimately.
submission, this is totally different. There is no
Okay,
2
please,
FIR.
we are
Transactions are
not-
different, cause of actions.
We
are
are
different.
not expressing any opinion, madam. You file your objection to this.
Achha.
This is not criminal appeal, this is criminal petition. You can file your objection. Heard Mr. Didas and when do you want?
After vacation only. Lordship.
There are 2 vacations. So
Bihu vacation.
which
and
one?
this
Bihu vacation. Okay. Ms.
As your
Das,
lordship pleases,
senior
and the
counsel.
convenient of the court.
listed by for the petitioner, Ms. M. Kumari, then standing counsel, CBI for the respondent. Also, this criminal petition under section 528 BNSS is preferred. Seeking setting aside and quashing of a first information report registered
पढ़े हुए
as
थे बोलकर कम
page 19 এর শেষ হয়, হ্যাঁ 19 এর শেষ হয় cost title silo cost title silo
petition
on
निकाल
18/8/2025. So para it is the contention of the petitioner that the affair registered as so and so is in continuation of another affair registered as RC so and so 12. Last of 12, ending with 12, registered on uh 3/5 or
3/5.
3/5
3/5.
2025. Full stop. Para Ms. Kumari, standing counsel, CBI has submitted that the subsequent affair is with regard to another transaction which is not related to the transaction mentioned in the affair registered on 3/5/2025. Issue notice returnable on immediately after issue vacate. 21
Okay.
January,
Okay. Okay. ma'am.
21/1/2026. The response CBI a file its written opposition to the instant criminal petition by the returnable date. Before that issue notice called to as Ms. Kumari.
Notice is
No
not
formal
required.
notice. The name of Ms. M. Kumari, standing counsel, CBI be reflected in the call list.
And assisted by N. Chaudhary.
Listed by Anj.
Please.
Much up.
Item 5.
Item 5, kindly the matter be kept for time being.
Item number 6.
Please, Your Lordship. Lordship, there is an application filed under section 528 of the BNSS. We are challenging the 528 of the BNSS. We are challenging the impugned order dated 23/6/2025.
528.
We are challenging the impugned order dated 23/6/2025 passed by the Learned Court of Hojai. The Learned Court of Hojai dismissed our complaint case on account of non-prosecution.
At what stage?
Learned, Lordship, it was for enquiry. It was for enquiry. It was posted for enquiry.
(406/420).
Lordship, my ground is that my engaged counsel did not inform me about the dates on which the CR case was posted on before the Hojai court.
So if you allege 406/420, right?
Lordship.
So what is the nature of the case?
Lordship, nature of the case was that the opposite party had deceived me for
No. It would be summons procedure or warrant procedure.
summon procedure.
Huh? How do you say that?
Summon procedure.
How? Why?
Because it was a complaint case, Lordship.
Complaint case means
Complaint lodged by the
automatically summons procedure case. Hmm?
Lordship, might be, it might be warrant also.
Might be, maybe summons, maybe warrant. You throw the issue to the court.
Lordship, it was a warrant procedure.
Huh?
Warrant
Why
procedure.
warrant procedure?
Because the law,
It will be warrant procedure or summons procedure. You file a complaint, right? Before the court. What happens thereafter?
Lordship, then the court took our deposition of the complainant
Complainant.
uh,
Okay.
under section 200 of the CRPC.
Hmm.
And after that, the court took deposition of one of the witnesses also.
Hmm.
After
That is
that,
under what? Under which provision of CRPC?
court took 200 under section 200 of CRPC.
Also witness also CRPC
No,
200.
Lordship, no, Lord.
Oh, you are looking at the file now. Be sure. Come back after preparation. After doing homework. List the case on.
Lordship, my ground,
Nothing is going to happen if your
Lordship,
petition
my
is
ground-
allowed. It will be restored.
Lordship, my ground is that I am living in outside of India. And I was not informed about the dates on which the complaint case was posted before the Learned Court of Hojai. So I could not
First-
contact my advocate also.
And this dismissal is under which provision?
Lordship.
Huh? Which provision?
Lordship, it had not mentioned, the Learned Court of Hojai had not mentioned.
No, you have to argue it.
Lordship.
Have you read the order?
Lordship, I have read the order. Order is at page number 18.
Read it. Then come. 5-1. On the prayer of Mr. Presidential Land Council for the petition on it. Place the case on 5-1. Read it. Go through the provisions. Nothing is going to happen. Your complaint is in a dead state. If petition is allowed, it will be revived. Nothing is going to happen within this time.
Lordship, another bench of this Honorable High Court, Partijoti Saika sir had, in the same cause of action, we had instituted a NI case also before the Hojai. That was also dismissed on account of non-prosecution. So that case was allowed by the Learned Court of Partijoti Saika sir.
Go by what is there in BNSS or CRPC. Have you understood?
Lordship.
First, my duty is to go through the provisions of CRPC or BNSS. 5-1. Just because some corneal bench has allowed, so I will allow with my eyes closed.
No, Lordship.
No.
But Lordship, it was on the same cause of action. Means we had instituted two cases.
Shall I proceed further?
No, Lordship.
Shall I proceed further and decide your fate now? Now. I have asked you to go through and you make submission in a proper and legal way. I have said that heaven is not going to fall till 5th of January. I have been repeatedly saying you.
Lordship.
And I was properly saying. Now you are insisting it.
Lordship, I apologize.
Number 7.
May I please, Your Lordship? Lord, in this case, Lordship, due to default in making payment in maintenance, Lordship, the petitioner has been sentenced to undergo 1 month civil imprisonment. Lordship, page 23 is the order. Lord, present Lordship, I am going to Lordship pay the entire area amount, and the petitioner is Lordship taking some step to.
What is this? What kind of proceeding is this?
125 CRPC proceeding was there,
Subdivision Judicial Magistrate,
my lord.
seeking maintenance. Then what happened? Final order has been passed.
My lord, the final order passed,
Where is that?
that is page 8,
Page 8.
10,000 to the one,
Contested one.
10,000.
Contested.
Lordship.
Contested case.
Yes, Lordship.
Not ex parte.
Not expect. Operative part, Lordship, page 18. 10,000 to wife and 5,000 to the child. 15,000
Hmm,
altogether.
yes.
But during this time, he has made some payment, Lordship, only 26,000 he has made payment. Now, Lordship, approximately 4 lakhs, Lordship, area is there. My Lord, the page 23, the
PRC. What is PRC again? Uh, So you did not file any appeal?
no, Lordship. Now I
Then
am going to, I am ready to pay the amount, Lordship. Some time will require because the petitioner is going to sell his landed property, Lordship.
what is the
Approximately,
time period given?
approximately, Lordship, 4 lakhs amount is become due. I am praying only for, Lordship, 3 months time, Lordship.
Pay an amount of rupees so and so. Per month, so and so, per month, date of filing of a petition. So paid to be adjusted, delivered. Then this miscase is for what?
My Lord, miss case was for maintenance.
$16.9.
Week is- Huh? I agree, sir. Pending.
This is subsequent proceeding is under section 128.
But they have exercised the power, Lordship, 125(3).
Warrant for, yes, issue a warrant for giving. You know, Your conduct is not,
At present, Lordship, I am ready to
how
pay.
can you approach that court first?
Lordship,
Your conduct is,
I'm admitting,
your
Lordship, my
conduct is that you avoid and you come to the High Court. You avoid that court.
my
No
lord,
relief can be granted.
my lord, I am, Lordship, admitting, Lordship, my conduct is not well, Lordship.
Not well, absolutely not well, very
lord,
bad,
My lord, yes, Lordship, I am,
very
lord,
bad. No,
only-
this,
my lord, only-
this kind of petitioner is not to be,
my lord,
even if any relief can be granted to, not to this kind of, you avoid that court,
my lord,
right, for years, and you come here to extend the period. First, you approach that court. If that court rejects it, then we can.
my lord,
So
already,
without first approaching the court, you come to the court.
my
You
lord,
avoid that court for 1 year.
my lord, already sentence is given for 1 month, Lordship.
So
Lordship,
you can ask for it.
my lord, if your Lordship.
That is a part of the, if warranty is recalled.
No. In final,
So be under what provision, what infirmity in this order?
my lord, I am not saying that there is a wrong.
What infirmity?
Only, Lordship,
We generally interfere when it is some infirmity. How to find infirmity in this order?
my lord, I am not saying that this order.
No, when there is no illegality
My lord,
or irregularity,
only,
where to?
only to ensure the payment, Lordship, that I am going to, Lordship, pay that.
That I cannot. Yes,
this-
Mr. Please assist,
Lordship,
Mr.
your Lordship is aware,
How
this
can it-
provision is only to ensure to
No,
make payment.
we do not find anything for that 482 for ends of justice,
My lord,
right? For ends of justice, some genuine issue has cropped up, okay. But here is a case who had avoided clearly the proceedings of the magistrate court for years.
my lord, that is, there I am not.
So wherefore, this order is perfectly in tune
If
with
you,
the
if you lost,
125.3.
only just, Lordship, I am paying for some time, Lordship, I will pay the entire amount. Petitioner is going to sell
How
the,
can we, sir?
my lord, petitioner is going to sell his landed property, Lordship.
You do it. There is no bar.
I'll pay, Lordship, the entire amount. If your Lordship gives some time, Lordship, and part payment,
I
Lordship,
cannot
during the
issue
pendency,
notice. I can't do anything.
during the pendency itself, Lordship,
I
I am undertaking, Lordship,
Cannot. If I interfere with this order,
my lord.
the district judiciary will say what kind of order is passed by High Court. Am I clear?
That is the, Lordship.
Huh?
If your Lordship,
See,
Lordship, may I
this
suggest,
is
Lordship,
the order passed by a High Court.
my lord.
No.
My lord, may I suggest, Lordship, one thing, Lordship, if your Lordship permit, let the matter be kept pending, Lordship, some time may be given, I will pay the amount, Lordship.
No. How
That
can
will
I give?
serve the purpose, Lordship.
Which is perfectly tuned with the provisions of law. Right. Where from I get jurisdiction?
Lordship, your Lordship can
No.
accept
This
520.
is not a case of for ends of justice also.
My lord,
It is a case of abuse of the process by the petitioner.
my lord,
Right. Avoiding the process of law deliberately.
only to,
No,
if your
I
Lordship,
am
if
dismissing.
your Lordship,
I am dismissing it.
if your Lordship,
You make
is
your
not
own
taken,
arrangement.
Lordship, he will send to jail, Lordship, that purpose will, Lordship, for recovery of the amount.
What is the purpose?
My lord, I am, that's my Lordship.
Legislature has made the provision for recovery.
My lord,
Those who do not,
only one chance, Lordship,
not.
Lordship may give.
where from, Mr. Khan?
My lord, let the matter be kept pending, Lordship.
On the prayer of Mr. M. Khan, learned counsel for the petitioner, please the case on so and so. That much I can do.
My lord, if your Lordship, direct Lordship, I will make some payment, Lordship also.
No, how can I?
Only, my lord, my problem is
Not
that,
possible, sir.
Lordship.
Had it been possible, I would have. Not possible. So that is the best I can do.
Lordship, oblige.
You can say, my case is pending. Appear through lawyer without physically, then can avoid. Perhaps, I don't know.
That can a date may be given, Lordship.
That's it.
19-1.
Oblige.
Item 8.
May I please, Lordship? My Lord, this petition has been filed for passing of the complaint case number, my Lord, 182 of 2025,
Hmm.
pending before the, my Lord, learned as DGM Koliabura, my Lord.
Hmm.
What happened actually, my Lord? The marriage between my daughter and the, my Lord, husband number 2 was fixed, my Lord. That is at page, my Lord, page 23, my Lord. Page 22 is the type copy, my Lord, page 23.
What happened?
Thereafter,
What is
my
the
Lord,
proceeding? This is complaint.
yes, my Lord.
And it
Thereafter,
has
my
been
Lord,
registered.
my
It
Lord,
has been
yes.
registered.
My Lord, this is my Lord, notice to internet marriage, my Lord, my daughter's marriage was fixed with the respondent number 2, my Lord. Thereafter, what happened, my Lord?
Mr.
He did not turn up, my
Come
Lord.
to the impugn order,
Impugn order is at page, my Lord,
17,
12, my Lord.
12.
Page 12, my Lord.
Same is page 17.
Yes,
Is it
my
not?
Lord. Yes, my Lord. Then, my Lord,
What was the procedure followed by the magistrate?
my Lord, when, my Lord, this PD complaint was filed, my Lord,
After complaint was filed,
My
it
lord.
was registered.
registered, my Lord.
Then thereafter,
Thereafter, my Lord,
complainant was examined.
complainer was, my Lord, complainer is present, my Lord, but it's not examined, my Lord. Complaint is present.
Have you made any statement that complainant was examined and
No,
witnesses?
no, my Lord. Actually, my Lord, what happened? At my Lord,
You have not understood my point. Now it is BNSS,
my Lord,
right?
my Lord,
To issue a notice to the
My lord.
complainant.
my Lord,
First, the complainant is to be examined.
my Lord.
Then his witnesses are to be examined.
Right, my Lord.
Right.
Right.
Thereafter, notice to be issued to the accused person for pre-cognizance hearing.
My Lord, my Lord.
That is what I am asking
My
you.
Lord, my Lord, yes, my Lord. You're absolutely right, my Lord.
Whether you have made statement that complaint was not
My
examined,
Lord,
his witnesses were not examined.
my witnesses and complaint not examined. What happened, my Lord?
Have you made statement?
I have
Then
not-
we can do shortcuts, sir.
My Lord. My Lord, I have filed a case against the respondent number 2 at Tinsukia, my Lord, at page 45, my Lord. Kindly see. And my Lord, my marriage ceremony was to be fixed on, my Lord, that is at para 5, my Lord. I have mentioned para 5, page 5, my Lord. Kindly see, my Lord. Buddha family on 5-4. So, my Lord, went to my son-in-law's house, my Lord. Firstly, my Lord, they have lost a case, my Lord.
The falsity will come later, sir, Mr. Rahman. I have asked a query. Have you made any statement?
That statement I have.
Huh?
Here, my Lord, I have not,
Those are into merit. Is it not?
my Lord.
He is not
That
having-
is a counterblast to this, that. No, the
Procedure
That, my
not
Lord,
challenged.
that, my Lord, I have
Procedure
made.
not challenged, ma'am.
Huh?
Procedure not challenged.
Not chilling.
Nothing is there.
Then it is premature. If he is not challenging the procedure, let him appear and contest the case, that this is not case for cognizance. This specific provision has been incorporated just so that everybody does not run to
Yes.
High
Lord.
Court for under 482.
Yes. It is a proposed accused that
Roman is not answering my queries. What happened on 12/12?
12, on 12, my Lord. I have to take instruction, my Lord.
Huh?
I have to take instruction on 12.
No, you take instruction first.
Well,
Whether after when it was filed,
it was-
complaint was filed, show me the original copy. (29/7).
22/7/2025, my Lord. That is at page 18, my Lord.
I have seen.
take it.
So you can agitate this point before the trial court. What is 223? What is 223 BNSS?
Yeah.
Yes,
2,
Mr.
2, 3.
Thereafter, if your plea is not accepted, you can definitely come. What is 223?
But he was not examined, my lord.
I don't know, it was filed in July. Might have examined, I don't know. That is why I've been
My lord,
asking
my lord.
you. And without hearing you, the magistrate is not empowered to take cognizance on the complaint,
My lord.
right? And you have a right to present your case,
My lord.
right, which you are trying to present here. So you avail that option, proviso. Have you read?
My lord, my lord.
Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard.
My lord.
So cognizance has not been taken. From
Well.
this order, it is evident. And you have been asked for hearing. See the order. So this appears to be premature. First, you make your presentation before a court. Court may close the complaint
My lord.
because it is a counterblast according to you,
My lord.
and it is frivolous. It looks like
My lord, my lord.
privacy. It looks like that,
My lord.
but you have to avail appropriate
My lord,
remedy.
my lord.
I have read your complaint, but question is,
My lord, I have no, I have no objection, my lord. If he doesn't make
I
my
observe.
daughter, I have no objection. But my lord,
I'll just observe that first you approach thereafter.
my lord.
Otherwise, that
let's
it,
take 12.
privacy, it appears to be premature.
No,
Hard.
612 is a consideration of charge as per the order.
Huh?
As per the order, my lord. Last page, my lord. It is
Last
kept.
page?
It is
Last-
kept for consideration of charge.
Lord, it is in my case, my lord. Tinsukia case, my lord.
That is different.
Oh, that is different.
Tinsukia case, my lord.
Come to page 17.
17. Yes.
17.
No.
Heard Mr.
No.
S.
People
S.
People S, my lord.
S. Rahman, learned counsel for the petitioners, and Mr. MP Goswami, learned edition public for the respondent number 1, State of Assam. Having regard to the facts projected in this criminal petition, preferred under 5 to 8, Bharatiya Nagarik Surakha Hanika 2023. This could, the criminal petition is taken up for consideration at the motion stage itself for the regions mentioned here in below post of para. The petitioner number 1 and the petition number 2 are the father and the mother of the petition number 3. Full stop. The petition number 4 is what is he? Is a son of the petition number 1 and 2 and a brother of the petition number 3. Right?
Right.
Full stop. Para. A discussion for solemnization of marriage between the petitioner number 3 and 1. What is his name? What is the name of the brother of the complainant?
Brother,
With whom your petition number 3's marriage discussion was going on?
petition number 3 is my daughter, my lord. My daughter.
Marriage discussion was going on
With
for
petition number
marriage-
3.
Huh?
Petition number 3, my lord.
Right. And what is the name of that man?
Respond number 2, my lord.
That his brother.
My lord. Respond number 2, my lord.
About Biachi.
Yes, my lord. Was to
Okay,
keep on
I'll look
Hafizul
into-
Haq.
I'll look into- With one, Saminul Haq. Who is a brother of the respondent number 2, that's complainant hearing. Full stop. Do discussion to solemnize the marriage between the petition number between the two families. For solemnization of the marriage between the petition number 3 and Sri Saminul Haq progressed to an extent, but this is Saminul Haq's father or brother? This Safizul Haq? Oh,
my lord,
maybe father, brother no hoy. Brother boli koi. So, the petitioners, the family of the petitioners requested the family of the respondent number 2 to supply the documents of Sri Saminul Haq to submit an application for registration of their marriage. Is registration of the marriage. Full stop.
Father, my.
Father.
father.
Full stop. However, at that point of time, the family of the proposed bridegroom backtracked. Full stop. Para. Agreed by such backtracking and alleging an act of cheating, the petition number 3 lodged a first information report
My lord.
before the officer in charge,
Dumduma.
Dumduma Police Station, on 25/3/2025, and the said FIR was registered as Dumduma Police Station case number 52
of 25.
stroke 2025 for the offences under sections 318 within bracket 4, 69 and 351 within bracket 2 of the Bharatiya Nyay Sanhita. Full stop. In the FIR, Sri Saminul Haq has been arraigned as the accused. Full stop. The investigation of Dumduma Police Station case number 52 stroke 2023 is going on since 25/3/2025. Full stop. Oh no, proceeded. Since proceeded, thereafter proceeded. Full stop. Upon completion of investigation, the IO of the case submitted a charge sheet in connection with Dumduma Police Station case number so-and-so, right, charge sheet number 61?
Charge sheet number 61
61 stroke 2025
Dumduma
on
PS 50.
12 5/2025, finding a privacy case well established against or privacy case for against Sri Saminul Haq for committing the offences under section 318 within bracket 4 stroke 69 stroke 351 within bracket 2 BNS. Full stop. Para. What is the proceeding going on?
Yeah, Page 54,
Case record.
my lord.
up.
Page 54, my lord.
54. On submission of the SARC, comma, why it has been registered as a sessions case? Any idea?
My lord, because there's a physical relationship, my lord.
Action.
Okay.
69.
By an order, sorry, on submission of SARC, comma, the case was registered as ERC case number 280 stroke 2025 within bracket GR case number 221 stroke 2025. Full stop. As one of the offenses, what is 69?
My lord, 69 is directly by court of session, my lord. It is sexual intercourse by employing deceitful means.
That is Sessions Tribal.
Session tribal.
As one of the offenses is Sessions Tribal, comma, the case records stood committed to the Court of Sessions Tinsukia, which on receipt of the case record registered the same as Sessions case number 109 within bracket T 2025. Full stop. On the Sri Saminul Haq, who has been surseated, comma, entered appearance before the Court of Sessions on 22/8/2025, and on his prayer, comma, he was allowed to remain on previous bail. Full stop. Para. Close on the heels of these developments. Para. The respondent number 2 as the complainant, who is the father of Sri Saminul Haq, comma, instituted a complaint before the Court of Subdivisional Judicial Magistrate, Koliabor, on 25/7/2025 against these four petitioners alleging commission of offences under sections 336, 296, 324, 351, stroke 3 within bracket 5 BNS. What is this? What is this?
My lord, 351 is,
BNS.
my lord, it is cheating.
BN.
See, here also, my lord.
Full stop. Para. By an order dated 30/10/2025, comma, the trial court kori bolun. The trial court directed the complainant, comma, that is the respondent to hearing, to take steps for issuance of notice to the accused persons, that is the petitioner's hearing, and posted the case on 12/12/2025 for what is SR? Service report.
Service report, ma'am.
Stroke hearing. Full stop. Para. The Mr. Rahman, learned counsel for the petitioner, has submitted that the complaint is a counterblast to the proceedings, to the FIR dated so and so agora sil- and sessions case number which resulted into submission of a charge sheet, and finally sessions case number so and so. Full stop. Para. Utha. And therefore, full stop. And therefore, not full stop. And therefore, the criminal petition, oh sorry, the complaint case has been instituted, abusing the process of law. Full stop. Moreover, comma, the ingredients of the offenses alleged in the complaint are absent. Full stop. Para. In the BNSS, comma, oh, sorry, section 223 of the BNSS has provided that a magistrate having jurisdiction while taking cognizance of an offense on complaint shall first examine upon oath the complainant and the witnesses present, comma, if any, comma, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses, and also by the magistrate. Post of the first proviso to subsection 1 of section 223 has provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Post of. Para. The trial court from the order dated 30/10/2025, comma, it is evident that the learned trial court is yet to take cognizance on the complaint, and by order dated 30/10/2025, comma, the petitioners have been put to notice. The notice has been issued to the petitioner, comma, who have been arraigned as accused a complaint, comma, to appear and
Appearance and hearing, ma'am.
for appearance and for to appear before the trial court. Full stop. It is inherent the proviso to subsection 1 of section 2(3) B and assess that before taking cognizance, comma, the trial court has to provide an opportunity of being heard to the accused persons to present their case. Full stop. Para. Evidently, comma, the proceedings of CR case number 128/2025 is presently at a pre-cognizance stage, and the petitioners have all the opportunity to represent their case before the trial court. First of, it is only after consideration of the version of the complainant and the petitioners, comma, the trial court would decide whether to take cognizance on the complaint or not. First of, in such view of the matter, the above view of the matter, the instant criminal petition found to be, appears to be premature, post of, this court is of the considered view that the petitioner should first appear before the trial court and to represent their case, to represent their case, including the proceedings already pending before the Court of Sessions in the form of Sessions case number so and so against the son of the complainant, right? Saminul Haq. Post of, it is expected that the trial court, after affording proper and reasonable opportunity of being heard to the petitioners, shall decide on the complaint whether to take cognizance or not by way of a reasoned order. Post of, if the petitioners are aggrieved by any region or any order passed by the trial court taking cognizance, the petitioners are at liberty to avail appropriate remedy under the law. So you close it there.
Item 10.
With the above observations, the criminal petition is disposed of.
May I please?
Yes,
Lordship, application under 528 of the BNS.
528.
Lordship. Lordship, may kindly come to page 20, annexure 2. That is the AB number, order passing AB number 1817 of 2025. Now, in connection to Lordship,
Petitioner Sarifun Nessa.
yes, Your Lordship.
Sarifun Nessa and
Rekibuddin Ahmed, Sonabar Ali and Merajuddin Ahmed, Lordship. Lordship.
Okay.
So, Lordship, this AB was preferred against the Mukalmua PS case number 162 of 2025, which was registered under section 318, 306, 319, 190, 3085 of the BNS, read with section 6 of the Assam Healings Prevention of Evil Practices Act 2024. Now, in this case, Lordship, the petitioners herein were not named accused in the FIR, and accordingly, they approached this honorable court apprehending arrest. And while order dated 31/7/2025, this honorable court, Lordship, if your Lordship may kindly come to page number 22, was pleased to grant interim relief to the petitioners and directed them to appear within a period of 7 days before the IO of in connection to Mukalmua PS case number 162 of 25, which was done accordingly, Lordship. Thereafter, Lordship, when the final date of hearing in the AB came up, Lordship, that is, if your Lordship come at page number 24, that is on 21 August 2025. Therein, Lordship, may kindly see para number 2, Lordship, which has been submitted. The learned additional PP submits that the charge sheet has been laid in the instant case by charge sheet number 180/25, dated 19th August 2025. And accordingly, Lordship, the prior engaged counsel withdrew the said anticipatory bail application. And this honorable court was also pleased to grant a liberty of 15 days interim extension to the petitioner's, Lordship, herein. Now, Lordship, in the meanwhile, Lordship, may kindly now come to page number 27, Lordship. So the named accused, Lordship, that is Rekibuddin Ahmed, Lordship, he was behind bars, Lordship, at that point of time.
Rekibuddin Ahmed means petition number 2.
No, Lordship. This is sorry. Petition number 2 is the son of the named accused Raifuddin Ahmed. If your Lordship peruses page 27, Lordship.
So understand who is the FIR?
Yes, Your Lordship. FIR is at
I
page.
can only follow from the FIR.
Lordship. FIR is at page 2, page 17, Lordship, paragraph 2, annexure 1. Because it's actually a very long FIR, Lordship. So I thought it's. If I may read, Lordship.
No, just I'll have a look.
Yes, Your Lordship.
Raifuddin Ahmed.
Yes, Your Lordship.
Gurudev.
Gurudev, Lordship. Elias
Okay,
Gurudev.
Gurudev.
Lordship.
Yeah, it is deeds of Gurudev.
Lordship.
And how these petitioners are related to Gurudev?
Lordship, petitioner number 1
Wife.
is the wife, Lordship.
Son.
Yes, Raifuddin is the son.
These three.
So, Lordship, these are relative and neighbors, Lordship, of the
Okay.
Lordship. So,
So in the PRS bail, you projected that one Raifuddin Ahmed is the man in
Lordship, we
cheating
were
and financial exploitation, right?
Lordship, we were not the named accused person.
You are not named accused
Yes,
person.
Your Lordship.
So it proceeded, interim bail granted, then
Lordship.
thereafter it was submitted that charge sheet was laid.
Yes, Your Lordship.
So it was withdrawn
Withdrawn,
to
Lordship.
avail appropriate remedy.
Lordship.
Then who is this? Oh, Raifuddin also. He
Raifuddin,
also came.
he came with a regular bail application. Lordship.
Regular bail. He was
Lordship.
arrested.
Yes, Your Lordship.
Okay.
And on
Then
the same day itself, the same situation arose,
now
Lordship.
come to page 27.
Lordship. Now, if I may read the operating part, Lordship. At the last paragraph, Lordship, if your Lordship says, page 27, last paragraph. Perusal of the case record and order dated 21/8/2025, passed by the Honorable Guwahati High Court in bail application 2440 of 25, reveals that though it was submitted before the Honorable High Court, that a charge sheet has been laid in this case, but no charge sheet has been put up yet. Considering the
Additional CGM.
Lordship.
Huh.
Considering that the accused person has completed a statutory
This
detention,
was by petitioner Rakibuddin.
Lordship.
Okay, for Raifuddin.
For Raifuddin, Lordship.
Huh.
So, considering the accused person has completed a statutory detention and no report in final form has been submitted till date, I deem fit and proper to allow bail to the accused person, namely Raifuddin Ali Ahmed. So, he got default bail, Your Lordship.
Default bail.
Yes.
Huh.
Now, Lordship, here the confusion arose is that because during the anticipatory bail hearing, Lordship, it was submitted, the charge sheet was laid down. And accordingly, the anticipatory bail was withdrawn, Lordship. So, thereafter, Lordship, when it came to their knowledge that on 27/8/2025, the charge sheet has not been laid down, there was some wrong advice which was given to them that it now, since charge sheet has not been laid down, they need not appear before the learned trial court at the onset and wait for the issuance of summons in the case. But thereafter, Lordship, what has occurred here is that, Lordship, there are two sections in this case, which are basically, Lordship, sessions triable. There is section 306 and 308 clause 5, Lordship. And now, Lordship, what has happened on the first date of appearance before the learned trial court, when the main accused Raifuddin was present, he appeared, and the petitioners were unable to appear. At the same time, Lordship, there is a technical lag which has come into play now, because the court of SDJM will not be at liberty to pass any appropriate orders for relief of bail in this instant case, considering it is a sessions triable matter. And the case will not be committed before the learned sessions court unless and until all the accused persons appear, Lordship. So that's why I have come before this honorable court to very limited prayer.
Oh, wow. It is, I know CRPC.
Lordship.
Okay, the bar under 436, 437 comes. Now it is a case of 209 small b CRPC. And you invited the trouble.
Lordship.
You invited the trouble
At the onset.
From the submission of PP.
At the
Is
onset.
it not?
At the onset. At the onset.
You invited the trouble
Lordship.
on the basis of submission of PP. Yes, Miss PP.
Lordship, actually, he was going through, so he had some emergencies.
So
That
then,
raise very limited.
no, just a minute. Law is also perhaps settled that perhaps even after submission of charge sheet, the provisions of earlier 438 CRPC can be invoked. Right?
Lordship.
That is one.
Lordship.
Second, when there is a specific provision, then 482, now it is 528, will not come into view. If those two propositions are correct, right, then this petition is not the appropriate remedy.
Lordship.
If steel can be invoked, 438, now it is what?
Now it is
482.
482.
Ah,
482.
that I think law is settled.
Lordship.
Then this procedure of filing criminal petition under 528 or earlier 482 CRPC is not to be accepted.
Lordship.
Yes, where
Lordship.
even after submission of
Oh.
charge sheet,
Sarsit.
the court can exercise 438 powers, 438 CRPC.
For CRPC.
Ah.
Lordship.
If that is a law,
Lordship, but what we are on here, Lordship, we are just not praying for, we are not praying for bail as such, Lordship.
no, you have to again,
Lordship,
you have to.
no, we are just,
Otherwise, the law is that SDGM cannot grant,
Lordship,
right?
Lordship,
528 should not be invoked,
Lordship,
right?
Lordship,
And once if it is sessions tribal and more than 10 years perhaps,
Lordship.
if
It
it
is
is
10
more than
years,
10
10
10,
years, Lordship.
10 years.
then he will be powerless once you appear,
Definitely,
right?
definitely.
The only option is
To-
438 CRPC, now 482 CRPC.
On that, if I may, Lordship, we are here before this honorable court for just a small prayer, that is that till the case is committed before the current court of session, we are not praying for an absolute bail here. We're just playing here that if the case can be committed, because upon our appearance, the case will be committed accordingly. And before the learned court of
I
session.
can ask for a report from
the-
the SDGM when, but he cannot commit.
Yes, at this
He
moment.
cannot commit without your appearance.
Definitely,
Right.
that is
He
what,
must appear.
That is the position I know, what report I should ask.
definitely, this Lordship, definitely.
That I know.
So our
And
prayer-
438 BRS bail,
Lordship,
that jurisdiction is available before this
Lordship
court.
is very correct.
In a
Lordship.
petition under 482 CRPC 528 BNSS,
Lordship.
I should not invoke that power.
Lordship, that is why our prayer is very limited. We are
What
just
prayer?
We are just praying for a very simple protection, Lordship, till the appearance, so that the
What
learned
appropriate remedy is available to you?
Lordship. But Lordship, the inherent jurisdiction can be, Lordship.
Oh, no. When there are settled
You will have to
positions,
appear.
when there are settled positions,
Lordship.
right?
Lordship.
Then why should I invoke? It should not be invoked. That is also, I say two propositions.
Lordship.
Two propositions.
Lordship.
Even after submission of SARSIT, 438 CRPC or 482 BNSS can be invoked.
Lordship.
And if a specific remedy is available,
Lordship.
then one should not
Lordship.
avoid that remedy. Both are settled,
Your Lordship is absolutely correct.
right? How can I grant that license
But
from
Lordship is,
this period to that period?
Your Lordship is absolutely correct.
And that may run into 2 years, 3 years also.
Lordship, you are absolutely correct, Lordship,
You
but
let go.
that is why.
We don't know, but he will still be powerless.
Lordship. Lordship,
He will still be powerless. With that protection, he will be sitting tight.
but nothing will happen with the
Nothing.
trial.
And SDGM will also be sitting tight.
Exactly, Lordship. The
And
Lordship
it
is
will go for 5 years.
5 years.
correct. Lordship
The
is
case
correct.
will remain there.
The case will remain in SDGM. He will be having
But, yes, Your Lordship, but on the contrary.
having protection
Lordship,
under this petition
Lordship.
for eternity.
Yes, but on the contrary, Lordship, that is what we are here for.
That is
the
an
trial.
impossible situation, Mr.
yes.
Das.
So, Lordship,
You have asked for an impossible situation.
just the interim protection till the appearance in the session court. When
Oh,
on the,
how can it be?
not a regular bail, Lordship.
How can I direct SDGM to commit the case accord?
No, not direct the SGM.
You will not appear.
No, we will appear, Lordship.
No.
Moment.
No,
we
Mr.
are-
Das, when this 438 protection you can avail.
Lordship.
Now, Miss
Date is not-
Begum, you
date-
bring it,
No, no,
I'll
no.
close it. That this, since he is insisting for something which is not appropriate.
Date is given for appearance.
Yes, that is given for appeal.
Oh.
No, but that is the.
You
thing,
get
we
that?
cannot appear there.
Oh,
Appear-
You get
Thank
you get the judgment, madam,
Lordship,
cut it short,
Lordship.
that when SARSIT is submitted, then still the protection of.
When SARSIT is submitted, Lordship, generally they will appear and the court will dispose of as
No, Mr. The position is something
something.
tricky.
Lordship,
Position is something tricky. It is
Lordship.
not that simple. for you to make submission is okay. They will be taken into custody.
Lordship, that
And
is also
because of, I'll
protection.
not say much.
Lordship, after protection.
I'll not say much because of the submission of the public prosecutor.
Lordship, that is.
They are in such court.
Lordship.
438. A remedy can be available.
Oh, that I will have to, Lordship, I will go through and I'll.
Find out after some time.
After,
Some time. Because he is insisting on it.
on that point, Lordship, I got it.
Good morning, sir.
Yes.
Thank you very much, sir, for giving me this opportunity.
Yes.
I'm Dr. N. Rajamarthandan, sir. I'm presently serving as Senior Superintendent of Police FRR of Barpeta, sir. This criminal petition number 1599 has been filed before this honorable court following the order of this honorable Guwahati High Court on 2nd of December, sir. While disposing of my earlier criminal revision petition, which was filed erroneously under 442 BNSS, the honorable court advised me and gave me the liberty to file afresh the matter under section
is that
5.
order?
Pardon, sir?
Is that
Yes, sir.
order?
Annexure number M, sir, page 33. Honorable Justice Pranjal Das has advised me and given me the liberty to file afresh the matter.
Is it partly allowed? You know, is 32.
33, sir. Yes, sir. 32, yes, sir. The 32 will be the first page.
Agreed by judgment and order dated past. Let us- Who is the judgment 24/3/2025?
Sir, that is in page number 35, sir. 35. That is
35.
order of the additional session, district and sessions judge, sir. 35 to 47. The operative part will be on page number 46, sir.
Still review please by the impugn or other charge and present. It is right. Has been included in the charge. What is 217 and 218 of
200 and
IPC?
Sir, a public servant
Is
in
it
why?
quoted? Is it quoted somewhere?
Yes, that is the component. Yes, sir.
Is it quoted somewhere?
Yes, sir.
Okay, it is inside the judgment.
Yes, yes, sir.
180 is police for the public servant in correct or writing with intent a person. So, 217. Where is 217?
217, sir. Actually, it is a
Yeah, it is page 43. Public servant disobeying direction of law. Yes, where is the charge from?
So charge from page number 86, sir. Sir, 85. The charge form, sir, the heading itself is very clear. Charge
Yes,
and
ma'am.
yes.
One section is
85.
85, I have. 27.
You are impugning which order? This judgment.
Judgment of the Honorable Additional District and
Ah.
Sessions Court, sir, upholding an obviously and clearly
Yes.
a typographical error.
It is Lordship.
Had Mr. and Dr. N. Raja Marthandan, the petitioner in person, and Miss A. Begum, Lanet, additional public prosecutor for the respondent state. So, this criminal petition under section 528 Bharatiya Nagarik Surakha Honor 2023 is preferred to assail a judgment and order dated 24/3/2025, passed by the Court of Granite, Additional Sessions Judge number 1, Kamrup, M. Guwahati, in Criminal Revision number 33, stroke 2024. Full stop. The criminal revision petition under section 438 BNS was preferred, seeking setting aside and quashing of an order, quashing of a part, the quashing of an order dated 21/5/2024, passed by the Court of Additional Chief Judicial Magistrate, Kamrup, Metro Guwahati, Trial Court, in PRC number 234/2023. Where is that order? 21/5/2024 by the
Yes,
additional
sir.
section
That is in page number 84, sir.
84.
That is the charge
Okay,
framing order.
that is 85.
85.
85.
85 will be the charge form. Yes, sir.
The revisional court, by the judgment and order dated so and so, has partly allowed the criminal revision petition by setting aside and quashing the charge framed under section 218 IPC on the ground that the ingredients of the state offense are not fulfilled. Full stop. Insofar as the charge under section 217 CR IPC, the revisional court has observed that since the offense under, since the charge for offense under section 217 IPC has been included in a charge form, the same has been upheld. With a further observation that the charge under section 217 IPC need to be specified clearly by the trial court. Post of the matter would require consultation, issue notice returnable on so and so date. As Ms. Begum has appeared accepted notice, formal notice, post of heard Ms. Dr. So and so, heard the learned counsel for the parties also on the interim prayer. Post of for ready reference, comma, the order framing charges are quoted here in below for below page 85. You type it. Page 85. Para from the order from the charge from the above order framing charge, it is evidently clear that the current trial court has used a form prescribed for charge with two heads, and the trial court had framed charges under section 218 IPC and section 98 within bracket small a of the Assam Police Act. Full stop. There was no specific charge framed under section 217 IPC. Full stop. In such view of the matter, comma, the operation of the impugned judgment and order dated operation of that part of the impugned judgment and order dated 24/3/2025, passed by the whereby the revisional court has directed to specify the charge under section 217 IPC by the trial court is state.
6th February. So the earlier criminal petition records may be tagged with this, sir.
Not required.
Not required. Okay, sir. Thank you very much.
Item 12.
May I please your lordship?
Mr. Goswami, you are sitting for which item?
In 6.
Please.
Effectively, in supplementary list. Okay. After 3 items or what? So how many items? Three items.
After 3 items, it will
Okay, come after 20 minutes.
May I please your lordship, this is an application under section 528 of BNSS
Hmm.
for quashing the Dispur police case 7/4/2025.
7.
My lordship, at this stage, my lordship, I am not praying for anything. If I can make out a case, my lordship will serve a notice and may your lordship may call.
Let
for
us
trial
have the
by-
FIR first.
My lordship, kindly
Let me
look into the
satisfy
page
first.
page number 18, my lordship, FIR.
18.
18, my lordship. 18 and 19, my lord.
Okay. Because for registration of so-and-so Leela Setri. Repeat case for issue notice.
Lordship.
Lopez, ma'am.
Not a fit case for issue notice, not even notice.
Lordship, then may I make my submission?
Make your submission.
If the after the police registered this case, my lordship, they investigated. After that, filed the charge sheet, my lordship. The lordship may kindly take a ask lordship attention. Page 27, my lordship. Here is the charge they have attested, my lordship. Where the victim herself denied for going for the medical legal examination, my lordship. My lordship, when the
It is read with section 64.
it's one of the ground, my lordship.
64.
64, my lordship.
64 read with 62.
Lordship, then my lordship, can I ask my lordship attention in the bail order where the honorable learned judge, after seeing the perusing the case diary, while it is mentioned that there are no materials on rape, my lordship. That is after perusing the case diary, my lordship. Kindly may my lordship take your lordship to the page number in the bail order, my lordship. Page 22, my lordship.
22, para
Yes.
10.
Para 10, yes, my lordship.
But
There are no
charge sheet
materials
has
of
been
rape.
submitted section 64(1) read with section 62.
My lordship, can I ask
Yes,
my lordship-
rightly observed. 64(1) is not there. But charge sheet has been submitted 64(1) read with
64(1).
section 62.
My lordship, my case is this, my lordship. May your lordship call for the trial court record.
Oh,
The
no.
lordship can evaluate
Hard,
either the
Mr.
charge sheet filed
absolutely
and
not.
the
This is really a brief. Hard, Mr. To go to the hard, Mr.
Aramin, my lordship.
Aramin Learned Counsel for the petition. And Miss N. A. Begum, Learned Additional Public Prosecutor for the respondent state. Post of this criminal petition is preferred under section 528. Hard case for Likiba, BNSS preferred. Checking, setting aside of a first information, one Likiba, serial number 1. First information report registered as Dispur Police Station case number 742/2025 under sections 329 within bracket 4 stroke 64 within bracket 1 stroke 62 stroke 351 within bracket 2 Bharatiya Nyay Honita. Next 2 charge sheet number 567 stroke 2025 submitted on 39/2025 submitted in connection with Dispur Police Station case number 742/2025 and 3 the criminal proceedings of দুটাই post of para. The affair of criminal proceedings of ZR case number 4371/2025. Full stop. The informant lodged the FIR on 3/9/2025 before the officer in charge Dispur Police Station, stating inter alia that she, a student aged about 20 years, is studying law in NEF Law College, Guwahati, and at that point of up till 2/9/2025, she was staying in a PG hostel at Anand Nagar, Christian Bosti, Guwahati. Post op. On informant had entirely alleged that at around 10:30 p.m. that's 11 p.m. on 2/9/2025, the petitioner entered the hostel premises on the pretext of checking the fence, full stop. The informant then requested him to inspect the room allotted to her and to repair or install hooks. Install hooks, HOOKS, full stop. The accused came into the room in an intoxicated condition and wearing only a towel. Full stop. The accused
Item. Mention for item. Once the date.
Yes.
Can I mention for item number 11 to advance the date to January 1st week or be?
No, that is not.
Item 14.
May please, Your Lordship. The petitioners are aggrieved by an order of whereby their bail, default bail granted to them has been, Lordship, cancelled, Lordship. Default bail granted to them has been cancelled on the ground of, Lordship, suppression of facts. Lordship may kindly see page number 53. That is the impugn order.
Who are the petitioners? Kishore 30.
Kishore.
Ram 30. Okay. Date fixed for report. As a
Yes.
petition filed by case number so and so. Arises out of petition filed by complainant. Who is the complainant?
Complaint, Lordship, respond number 2, Lordship.
Moran.
Yes.
Stating about grant of all bail. The process. 1710. Is submitted that by suppressing perfect conviction. The Honorable Court of Person called to cancel the bail granted. This person must submit pattern to custody. And since no search was filed that day, outside question of determination is produced. Yes.
Lordship. Initially, the case was registered under section 103.
So on 17/10/2025,
Lordship.
25, what transpired before two court?
Lordship.
What is the two courts order?
Lordship, actually, what happened, the petition number 1 never filed any bail application.
Let us see the order.
Which order, Lordship?
17/10/2025, two courts passed orders one by one.
First, Lordship may kindly see that page number 32.
32.
It is a session code order, Lordship. Page 32.
32, 17/10.
Yes, Lordship, this is very important because Lordship, we may kindly see para 1. The part charge sheet previously submitted has been received by the court.
Okay,
That is
in the impugn order, it is held that part charge sheet is no charge sheet.
No charge. Therefore,
Let us
default-
accept that position for the
Yes.
timing,
Yes, Lordship.
right?
Lordship. Then, Lordship, this bail application was preferred on behalf of petition number 2, Poonam Tati.
What is the relation between the two?
Petition number 1 is the father, who is the
Father.
daughter.
Father.
Then, Lordship, this court, Learned Court of Additional Session Judge FTC to hold that since charge sheet is late, even though it may be a part charge sheet, and it is sufficient to take cognizance. Lordship, therefore, Lordship, the compliance to 173 is 173(2) is there. Therefore, Lordship rejected the bail plea.
On the premise that
Charge
charge
sheet
sheet
is
has been submitted
submitted.
in 17/10/2025.
Before that, but 1710,
Before that,
1710,
whatever. And even if it is part charge sheet also,
yes, Lordship,
right?
it was sufficient to take cognizance.
Then what is the other order?
Other order, Lordship may kindly see page 37.
Is
37. There is the order granting default bill. Here, Lordship, para 2 may be seen, Lordship. Progress report as called for is received from the IO stating that the instant case has been partly charge sheeted. By Dumdua PS case number so and so, dated so and so, under section so and so. Further, the IO has stated that supplementary charge sheet will be submitted before this court after collection of FSL report. Then, Lordship, during the course of production, accused Poonam Tati, petitioner number 2, stated that she does not want to proceed with private counsel due to financial hardship and further prays for legal aid assistance. Having considered learned assistant LADC so and so, Tinsukia is appointed to defend the accused in the present case. Inform all concerned accordingly. At the same time, a same petition hearing number so and so filed by the learned assistant LADC and has prayed to allow the accused person, namely Poonam Tati, to go on bail on the ground that the accused person
in
has
another case on 17/10/2025.
on
They were represented by a private counsel.
by private counsel. Thereafter, before the court below, he was given
Because a private counsel cannot be at two places at the same time.
Lordship. And she also
Because he will attract bar council rules.
Lordship. In Lordship, and also she expressed her financial Lordship hardship. And thereafter, that petition was filed by the LADC, seeking default bail that no final form has been submitted and 91 days has elapsed from the date of remand, Lordship. Thereafter, moreover, also seen the petition file number so and so filed by the learned counsel appearing on behalf of the accused Kishore Tati. Is the petition number 1 to go on bail on the grounds that the accused person has completed the statutory period judicial custody and further prays to release the accused person on bail by virtue of his indefeasible right guaranteed under section 187(3) of the BNSS. Thereafter, Lordship, the trial court observed accused person, namely Kishore Tati and Srimati Poonam Tati, have already
Case
completed
of murder.
murder, Lordship.
Okay, 103 is
103.
equivalent to 302.
Yes,
Lordship.
Okay,
302.
okay. Murder.
And this is the Lordship elder sister of the respondent number 2, Champa Moran. Then, Lordship, that does Lordship may kindly see para 4, page 38. Does the accused persons, namely Kishore Tati and Poonam Tati, have already completed statutory period of 90 days in jail? That apart, no final form has been received from the IO so far. Hence, they were granted Lordship default bail. And Lordship, they were both represented by different set of counsel. One Lordship LADC,
Obviously,
one LADC, and the second one is Lordship by private
first you
counsel.
withdraw your own private counsel.
Then
That
she will
that
give
is
the-
also an important factor.
Lordship,
On that day,
on that day.
before
day.
another court, your private counsel was arguing in another court for bail.
For bail.
So you sought withdrawal of your private counsel before another court. Court engaged another legal aid counsel, right? Then he argued the matter.
He filed
Yes.
petition.
And the private counsel was arguing the matter in the other court,
Another court.
right?
That is
One court rejected,
one
one
court
court allowed.
allowed.
And who is in fault then? Whether the court is at fault or the counsels are at fault or the petitioner.
Petitioner. Petitioner was in.
Court cannot be at fault. They may not be aware that another petition, similar petition was moved in another court.
Yes.
And it is clearly mentioned in page number 56, suppression on
Yes,
misrepresentation.
Lordship.
Ah.
We also, Lordship, I also want to, Lordship, apprise that when there is no charge sheet, that part charge sheet, Lordship, that honorable.
Still they-
Part charge sheet is okay. I have said, I have read this order and I go by Kopil Wadhawan.
Kopil Wadhawan.
Right, let us go by that. But at the same time, the application
Fact-
was moved
Moved.
after that for cancellation. Right, now cancellation, application for cancellation of bail was considered by the court
Considered.
and suppression of fact was taken as a factor. Right. Now you have to do that because your thing was allowed.
Lordship.
Somehow by one court's order, though another court rejected it, the higher court rejected it,
Lower court.
the other court allowed. So your bail was, I don't know what happened, or which one will prevail. There is another matter. Otherwise, the order of the High Court should prevail. Where your bail application was rejected, rightly or wrongly,
Lordship.
but it should prevail. Then that order will prevail over that. We don't say it nowadays lower court, but trial court, right? So that order had to be revised. This was the order,
Yeah, that was the order.
huh?
That was the order. Page number 32.
32.
32. That is the Lordship rejection of the, by the learned session.
No, rejection was by learned session judge.
Lordship.
Petition was allowed by CGMC. Thereafter, what you did for that session judge order? What you did?
No, we did not challenge that.
You did not challenge this. So it is an anomalous situation now.
And that is pertaining
who has
to-
passed this order? Or this is a bail cancellation order?
Bail cancellation order.
Right,
By the learned-
unless that is not touched. That remains again. Right or wrong? He has held part charge series enough. But this order is passed by whom?
Additional CGM Lordship.
Additional session judge. But how can he revise his order? Additional session judge. Tricky situation.
That is what Lordship, but that is part, that pertains to petition number 2.
We'll have to examine it, otherwise it's
Lordship,
difficult.
it's a very much tricky.
We
because
cannot, because it touches upon the law. Procedural law.
Maybe he have got knowledge that default, so immediately he made this plan.
That pertains to only petition number 2. Petition number 1, Lordship never preferred any bail application. But also,
Lordship, if
No, Lordship.
voter get bail,
no Lordship, one is
No,
Lordship.
so far petition number 1 or whatever daughter is concerned, she apparently moved 2 bail applications before 2 courts on the same date. On the same ground. On the same ground, default ground.
No, earlier, it was pending since earlier. The
Huh?
Session judge order.
But session judge has, because the ground urge is same. Is it not?
No, that was on merit, but session judge held that Lordship since the charge sheet is
Uh-huh.
made.
So on default ground, he rejected it.
rejected it.
On seven,
Ah.
that's rejected, holding that that is a sufficient Lordship.
So default, he said default, bail on default ground is not maintainable Because charge sheet has already been submitted.
Lordship.
Maybe it is part,
Part certificate.
but in fact, charge sheet was submitted, right?
Charge sheet
Lordship.
was, Lordship, that charge sheet was submitted before
That
that.
part.
Part.
So, what do you have challenged now?
That cancellation order, Lordship. That page number,
But
Lordship.
the session judge order,
Is 53, no?
because he additional whatever, the creation is yours. The creation is yours. And if you don't challenge it, the session judge order, how can the CGM's order can
Prevail.
you have to, I don't know, we have to do the challenges, then only we can somehow
First that, then only he can touch
that the session judge order is bad.
without going to that.
And thereafter we can address regarding suppression, whether there was really suppression or not. Otherwise, we have to uphold it that it is not challenged. Right or wrong is a different thing. Mr. Hassan, you think it over without setting aside of this, and there is good ground to set aside the sessions judge order, but until it is set aside, it holds the field and it holds sway over CGM's order. Other factors are different, suppression or not.
But that pertains to petition number 2.
Whatever, it is combined order.
No, that is the separate. Petition number 2's bail application was rejected.
And that
Right, but-
again, suppression.
Petition number 1 never suppress anything, Lordship.
No, that I am saying that cancellation order is in respect of both the petitioners.
both.
Right. Session judge order is in respect of the daughter.
Daughter.
Then anyway, we have to decide on the suppression factor. And the learned additional session judge has dealt with the issue on merit on the basis of Supreme Court judgment. Where is the scope for interference otherwise?
That is
And
there.
more
but-
particularly, it is not that these two are alleged to be involved in the murder of the lady.
The lady was the Lordship wife of the petition number 1.
Wife. So daughter and father killing
Mother.
wife and mother.
The daughter from
Where is the affair?
my Lordship.
Daughter from not own mother.
Yes, earlier.
Stepmother.
Hmm?
Stepmother.
Oh,
Fair play.
daughter.
Page,
Stepdaughter.
page 18, Lordship.
Stepdaughter.
Stepdaughter.
Okay.
Page 19.
Oh, stone slab. Think it over, some more challenge is to be made or not, then we can decide. Otherwise, something is, there is otherwise so far as the petitioner number father is concerned, that has to be addressed on the merit as regards cancellation of bail. That it can be done.
Not father, daughter.
Yes. Yes. So far as father is concerned,
Lordship,
Father never filed any bail application.
once the daughter get bail, Lordship, father will immediately get on same ground, Lordship.
no.
But now the thing is that he have
Not
to
all,
file
father got the bail on default,
on default.
right? He was not before the sessions,
Sessions court.
right? So, if that is not so, the ground that there was
Agreed.
suppression of fact,
Lordship,
right, on the part of the father
father.
is not there.
There it is.
Against daughter, yes. She moved two applications before two courts at the
Two
same
courts.
time on the same date.
For this, Lordship, records will be required, Lord. I'll have to go through, Lord.
But so far as the father is concerned, we can dismiss the petition for daughter. But so far father is concerned, there apparently no allegation of.
That's for that only, Lordship.
Separation
I'll
of
have to
right.
go to the TCR, Lordship. I'll have to see the TCR, Lord.
It is there, Lordship.
Okay, get the,
TCR is there?
No, TCL, no, I have annexed the orders, Lordship.
So I'll have to go through the.
From that, the
TCR, Lordship.
so far father is concerned, there is nothing apparently. We stay in the cancellation of father's bill.
Lordship, may kindly state.
Because he got a ground in, no, don't ask for. I'll write now cancel it. Apparently, suppression. I did it very tactfully.
Lordship.
I'll not say in much words. You are too clever. Daughter is too clever. I'll not say much. Heard Mr. N. Hassan, learned counsel for the petitioners, and Ms. A. Begum, learned additional public prosecutor for the respondent number 1 state. Post up this criminal petition is preferred. Under section 528, PNSS is prepared against an order dated 11/12/2025, filed by the, passed by the Court of Learned Additional CGM. Tinsukia?
Lordship.
Tinsukia. In petition number 759/2025 dated 5/12/2025 and petition number 780/2025 dated 9/12/2025, both filed by the respondent number 2. Complainant, who is also the informant in the FIR lodged in connection with Dumduma Police Station case number 129/2025, registered for the offenses under sections
1031.
61 within bracket 2/103 within bracket 1 BNSS on 17/7/2025. Full stop. Yes,
Only
para-
BNS.
Only BNS. Okay, 103 BNS. As per the FIR lodged on 17/7/2025, the two petitioners had allegedly murdered the informant's elder sister, Monisha Tati. The disease, Monisha Tati, was the wife of the petitioner number
1
and the stepmother of the petitioner number 2. Para. The two petitions, petition number 579 dated stroke 2025, page 53, dated 5/12/2015, and petition number 780 stroke 2025 dated 9/12/2015 were filed by the respondent number 2 stroke complainant stroke informant, seeking cancellation of the bail granted to the two petitioners on 17/10/2025, apparently due to default on the part of the investigating authority to submit charge sheet within the prescribed period. Full stop. The materials on record go to indicate that prior to 17/10/2025, comma, only a part charge sheet, only a part charge sheet was submitted.
That was returned by the office.
Full stop. Para. Having issue notice returnable on so and so, having, as Ms. Begum, having gone through the, where is the session judge order?
Page number 32.
Having gone through the order dated 8/8/2025 passed
No,
by
Lordship,
the
1710.
Huh?
Page 32.
32. Okay, 17/10/2025 passed by the Court of Learned Additional Session Judge FTC /2 Tinsukia in bail application number 206/2025 in brackets Srimati Poonam Tati versus State of Assam. And where is the other one?
Page number 34, Lordship.
34.
Lordship, 37. This is the
Page number?
37, default bail order, Lordship.
37.
Oh, sorry.
Order dated 17/10/2025 passed by the Court of Learned Additional Chief Judicial Magistrate Tinsukia, comma, both in connection with
Dumduma PS case number.
Dumduma Police Station case number 129/2025. And it is noticed that the petitioner number 1 did not prefer any application for bail before the Court of Learned Additional Sessions Judge, FTC so and so, and no order for bail on default was passed against him by the state court. Full stop. The impugn order dated 11/10/2025,
1112.
11/12 has been passed, cancelling the bail in respect of both the petitioners on the ground that there were suppression of facts on their part in seeking default bail. Full stop. Having regard to the fact that the petitioner number 1 was not was a petition filed a bail application only before the Court of Learned Additional CGM so and so. That part of the order, that part of the impugn order dated 11/10/12/2025, by which the Learned Court of so and so has cancelled the bail on the petition number 1 is suspended till the return. Father by default.
4th February.
Not daughter.
Records.
This year may be called for. This year may be called for.
Records.
Only like a separation or not? Which CCR required? You write down. Let the second coverage of TCS pertaining to. Write down.
Lordship.
Yes, number.
Please, Lord.
Mr. Goswami at 2.
We did it.
Number 5 leftover item. Can it be taken up after vacation, Lordship? I'm today not feeling well. Lordship.
Number?
Item number 5, Lordship.
Already killed. Order. Okay. On the prayer of Mr. D. Sharma, Land Conservator petition, is the case on?
After vacation.
Did you did?
Highly obliged.
My lord, I beg to mention, my lord. Item number 39, my lord. One provision, my lord, the section is written 482 in place of 528, my lord. May I correct it, my lord? No order has been passed yet, my.
Wait for your turn. Wait for your turn.
Item 15.
May I please your lordship? Kindly ground for time being.
Time being, we don't know.
Supplementary list. Item 34.
May please your lordship. Kindly pass over for this day, my lord.
What are they?
Adjournment.
Okay, under prayer of Mr.
A Khalek.
Learned counsel for the petition, list the case on suspension.
Oblige, my lord.
Item 35.
Madam. May I please?
Yes.
The FIR is interesting. If your lordships kindly turn to page 18.
Some
May I
oil
just- May I just place it, my lord?
pipeline, yes.
With due respect, I would like to inform you that yesterday on 31/7/25 at around 11:30 PM, DIAO Security Patrolling Team led by SPO Dharmananda Bhuya and Chabua Bike Patrolling Team Bhavan Gogoi and Dharani Gogoi detected one tapping point on oil's 4-inch gas line connecting Chabua FGZS to well 14 in Udalgari Gaon, Chabua Tea Estate. Hatigar 1B section. It is found that miscreants have damaged the pipeline by drilling upon it and installing one tapping point to pilferage condensate, resulting in a huge loss of production and partially damage the pipeline. One pair of 4-inch iron clamp, 400 meters of PVC, 60 meter of PVC 12.7 mm hydraulic hose pipe, 3 numbers of 1-inch valve, 20 numbers of drums of 50 volts each, total about 1,000. Its condensate, 3 numbers of handmade filters were recovered from the spot. Repair of the pipeline is going on now. The following persons were seen near the tapping point when our security team reached the spot, but taking help of darkness, they fled away. Lokhindra Bora, Nitul Bora of Chetia Pahar village, and Dipankar Kaura and Arjun Patra of Kumbhat, Habigaon. Sir, such type of unauthorized manipulation of pipeline may lead to safety hazards, which is harmful for the environment and also polluting nearby area. This type of miscreant activities causes revenue losses to the company and to the government exchequer also, which is covered under the PDPP Act, Section 3, and the Petroleum and Mineral Pipelines Acquisition of Right of User in Land Amendment Act, Section 15. That such incidents has been frequently happening in the nearby areas from past few days. In view of the above, I request you to investigate the matter and nab the miscreants involved in such steps and recover the stolen articles. So this is how, my lord, the FIR was. At about 11:30 at night, admittedly, there was darkness, and it is said that taking advantage of the darkness, they have disappeared. And these are the 4 names, out of which 2 were arrested and who have already been granted bail. That is this Dipankar Chowra and Arjun Patra. And the present petitioners before lordships are this 1 and 2, Lakhindra Bora and Nitul Bora of Chetia. So this is the position, and the act which is invoked 15.4. If your lordships kindly turn to page 29, the act starts at page 24. Page 29 is para 15. Whoever willfully obstructs any person in doing any of the acts authorized by section 4 or section 7 or section 8, or willfully fills up, destroys, damages, or displaces any trains or mark made under section 4, or willfully does any act prohibited under section 9, shall be punishable with imprisonment for a term which may extend to 6 months, or with fine, or with both. 15.2, whoever willfully makes or causes to make any unauthorized connection or removes, destroys, or damages or displaces any pipeline, or under section 7, willfully inserts any device to extract petroleum product or minerals from such, or willfully disrupts supplies being made through the pipeline, shall be punishable with imprisonment for a term which may extend to 10 years and shall be liable to fine. Then if any person convicted of an offense under subsection 2 is again convicted, we are not concerned with that. 4, my lord, which is specifically mentioned at page 30, whoever with intent to cause or knowing that he is likely to cause damage or destruction of any pipeline laid down under section 7, or causes by fire, explosive substance, or otherwise damage to the pipeline being used for transportation of petroleum products, crude oil, or gas, with intent to commit sabotage, or with the knowledge that such act is so imminently dangerous that it may in all probability cause death of any person, or such bodily injury likely to cause death of any person, shall be punishable with rigorous imprisonment, which shall be not less than 10 years, but may extend to imprisonment for life or death. So basically, my lord, 15.4, if we go through the present FIR, it only says that security people were going around 11:30 at night, and they saw some people running away, taking cover of the darkness. They have named 4, 2 have already been granted bail, we have not yet been arrested, we are before your lodge. So there is no act attributed to any of us or any of the petitioners before your lordship that they were seen doing certain things to damage. If the only allegation is that you were seen there on the spot and you ran away, that doesn't satisfy the requirements of this section, either of 15, far less of 15.4. And my lord, therefore, my lord, the investigation has been going on, and the one who has been granted bail is at page 20. 32, my lord, I'm sorry, 32.
This is a petition for what? Quashing of the proceeding. Quashing of the FIR.
Basically, for my lord, we are questioning the FIR because if you accept the charges also, as far as the petitioners are concerned, it is nowhere anything is alleged against them. Only presence at night and running away doesn't cause an offense under this act.
Right, but some seizure was made.
These are, yes, but they are not alleging that this was found from
This
them.
matter, it is that always to be caught red-handed.
True, my lord.
That may not be possible in all cases.
No, I quite agree, my lord, but kindly see the situation. At night, with only allegation that they were seen there. If you are only seen there, my lord, it may be a road nearby.
For that purpose, we can call for the case
Yes,
diary.
Yes, your lordships can do that.
Page number 21, Lordship.
Page number
21,
21.
Lordship. In this regard, a perusal of case diary. Last,
Hmm.
third paragraph, Lordship.
Okay. Here's the accused petition. Okay. There are provisions like NDPS Act.
Yes, yes.
Huh?
Yes, 15(4). And bar for anticipatory bail is also there.
438 is also not applicable.
No, it will not be applicable if the offense is there. 16D is there.
If it is under section 15(4).
Yes. 15(4) and 16D. 15(4) doesn't explosives, my lord. It doesn't come at all.
No, otherwise damage, it is there.
Damage.
Yes,
Otherwise is all inclusive.
yes.
15(4). Any pipeline laid under section 7 causes by fire or
Yes,
explosive substance or otherwise damage to the pipeline.
yes. Otherwise,
So otherwise is very vague word.
my lord,
With
the
intent to
intention
commit
has
sabotage
to
or
be
with the
there.
knowledge of such act. It is any petroleum product, inflammable product is likely to cause death, maybe bodily injury.
Correct, my lord.
16D.
This will not, the ingredients are absent so far as this FIR is concerned, my lord. To attract this,
Let the
We'll call for
CDP
the
there,
case diary.
Lordship.
because at page 32, my lord, if your lordship sees the order passed in respect of those who have been arrested earlier, not the petitioners, but who were, 4 of them were named. And your lordship,
Not much discuss. They were arrested.
they were arrested and then they got bail. And that bail order is at page 32, my lord.
Perhaps provision of section 16C was not followed. 16C, while granting bail,
Yes,
that perhaps was not followed.
that I don't know.
That recording like section 37
Yes.
was not there.
No,
Was not
but
there.
all
Or like
that I was trying,
43D5.
no,
That was not there.
I was only trying to show, my lord,
Ah.
your lordship is right there, but what I am trying to show is
And section 16D.
the
Section
2 other persons who
16D
were.
bars 438 application. No, regarding
Correct.
ingredients. Okay.
No, I follow. No.
16D bars 438.
Yes.
এটা হেমা মিশ্র বুলি আছে চাওকচোন। Have you gone through Hema Mishra?
Huh? Which one?
Just a minute. Check.
Which one?
Let me check. Hema Mishra, Justice Chandrachud, Uttar Pradesh.
I have not seen that.
Just a minute. Let me find out so that correct proposition is. Because in Uttar Pradesh, this 430 was modified.
Yes.
And in the state of Uttar Pradesh, no application for anticipatory bail.
Well, initially it was not there.
It was not there. No? Because there is an alternative prayer also. See, Mr. Bora. No, the question may come up because of 16D. You have an alternative prayer also.
Yes.
I don't know why 482 was not included. So it to sir.
No, my lord, your lordship is right in pointing out this. Only thing is, my lord,
No, regarding alternative prayer,
Correct.
not regarding quashing, I'm
no,
saying.
no. But your lordship is right that 430 was barred there.
Ha.
And in spite of that bar, it was said that it is open under 226
Right.
to take the matter.
Oh, why, I don't know why it was deliberately earlier CRPC 482 has been not mentioned. Whether taking notice of it or without noticing it, I don't know. Because 482
Yes,
CRPC is not mentioned in the judgment. Right.
true.
Otherwise, in Bhajanlal, it says 482 CRPC or 226
True.
Constitution. But here, I don't know for what reason 482 CRPC is not mentioned.
True.
I have not read the entire judgment since no occasion arose earlier.
Only thing, Miller, I may point out, this question as to whether under 226 you can have a quashing
Ah, yes.
was a central issue which was decided by the Supreme Court in that Sanchita case. Sanchayate or some case in Calcutta case.
Bhajanlal, it says clearly 226.
But that was the first judgment where it was said that quashing under Article 226 is possible. Notwithstanding 482
Yes,
and
yes.
all that.
Then Bhajanlal says 482 CRPC or 226 Constitution.
Correct. Because it came later possibly.
Yes.
Because-
The paragraph 105 perhaps.
Yes.
Specifically mentions.
Yes.
But why in this judgment 482 is not mentioned, I don't know.
And this is possibly they were only considering in the context of the bar.
Oh, this is only in the context of your alternative prayer.
Correct.
Right.
As far as
And-
the lot 482, 226 is concerned, that Sanchita, I
So
think it is.
quashing prayer is open,
Open.
but because of this judgment, the alternative prayer may be and plus Niharika. That in 482 don't give such relief. Niharika infrastructure. Both this regarding alternative prayer. So far as the main prayer for quashing, that is open under 482.
Yes.
So case diary.
Yes, that will be better.
Because the otherwise in the bail order, incriminating materials are there.
Lordship, they are not.
That is what I was trying to show from the other case, where it is said that investigation is already going on, but nothing is there. So that is why.
Up to date case diary.
Yes, I think.
When immediately after, you
Immediately
will be
after
available?
application.
Yes.
First week of
Yes,
January?
yes, your lordship.
Uh,
Whatever it's convenient.
it can be possible.
Lordship on 9 January.
9 January?
Friday.
Okay, hard. Mr. P.K. Goswami,
And,
Narayan Senior Council.
Only my prayer will be, Milord, he has not yet been arrested.
Dibrugarh.
So at least no coercive action.
That is also Niharika. Niharika is putting the hindrance. Niharika, no coercive action, that kind of order should not be passed in 482. Again by Justice Chandrachud. Again by Honorable Justice Chandrachud.
226 is, if it is open.
No, we have to,
then obviously.
we have to follow the mandate also.
No, if Milord, substantively it is held, as it was done.
Yes, yes.
That notwithstanding anything in the CRPC, this is 226 is a power which confers the power to quash. And therefore, any application filed under 226 praying, one can conceive of a prayer also in interim that since he is out in the area while moving the court, at least two others who were arrested, they have also granted bail.
I don't know whether, I don't know, 528 can be clubbed with 226.
Yes.
That is again an issue. We have to follow all these dictum also.
No, I quite see, but so far as that issue is concerned, in that Calcutta case where that for the first time that money was taken from the public and finally it was not able to peerless case, my lord. So
Niharika to sound Niharika.
that is, I think, 95 or 2005. One SCC.
When it was registered? August. You can wait for 10 days. They can wait for 10 days.
And they can also wait for 10 days.
Sound Niharika to.
Only thing is that in the going
No.
to the case diary,
Hmm.
he earlier his bail was rejected that he is not cooperating and he is a member of.
Oh,
syndicate.
their application.
Lordship, that. Page
Oh,
number
that
21,
allegation is
Lordship.
there.
Huh?
That
In the page number 21, I have
21.
21, Lordship.
that allegation is.
Oh, pre-arrest bail
That is, Lordship.
of this petitioner.
Yes.
Lordship.
Yeah.
After going to the case diary, Lordship.
Oh, then it will be
So,
difficult.
Lordship. So according to case diary, he is a
But
member
it
of
is
the
a
syndicate.
concurrent jurisdiction.
Last, third paragraph, Lordship.
That
In
is
page
there.
number 21, Lordship. For that.
But Mr. P.K. Goswami, Learned Senior Counsel, tested by Mr. B.P. Bora, Learned Counsel for the petition, and Ms. A. Begum, Learned Additional Public Prosecutor for the respondent state. This application under section 528 BNSS 2023 read with Article 226 of the Constitution of India is preferred, seeking setting aside of a first information report registered as Tengaghat Police Station case number 45/2025 under sections লিখে দিব হ্যাঁ page ভুল নকৰি page 19 আছে. Okay. The petition, Mr. Goswami, Learned Senior Counsel, referring to the FIR, has submitted that the two petitioners were merely seen at the alleged place. This alleged pipeline, wherein the informant and his team noticed tapping point for pilferage Most of certain items were found near the alleged place of occurrence. Most of he has submitted that those it is not mentioned that those articles stroke items belong to any of the petitioners. Full stop. Matter would require consideration, issue notice returnable on 9/1/2026. For consideration as Ms. Begum has appeared accepted. No further, no formal notice. The additional public prosecutor shall produce the case diary of Tengakhat Police Station so and so on the next date of listing.
Next date is, my lord.
9/1. Mr. Bora, you go through it, why 482 was not referred to in Hema Mishra. And there are subsequent judgments also following Hema Mishra.
Item 36.
Problem.
This for washing of the complaint case.
Petitioner landlady.
Yes.
Petition number 2, husband. Approached by opposite party to purchase 1 kotha land, eventually an agreement was entered into but owing to dispute. Opposite party cancelled the opposite party raised by the petition number cancelled the petition issued a letter to the Swens. Okay, wherein the 3 checks?
Return.
Letter.
Letter, my lord, your lordship, 3 checks is 73, my lord. It was returned to them, my lord. Payment was made. Then again, pay 73.
73, 9/8/2023. Okay.
Opposite
Then
complaint and return.
Opposite party reply. Let us see the reply.
Reply, my lord, it's pay 73 is the return, my lord.
Return of
73.
registered letter. Okay, to the petitioner.
Yes.
Number 1.
Yes.
I'd like to submit, I have already filed a civil suit under provision of friends. When it was sent?
Page 70, my lord. 70.
70.
My lord.
It was 6/7.
Yes. along
And
with
when the suit was instituted?
Suit was instituted, my lord,
When
complaint.
the suit?
Title suit, my lord, on 19 July.
19 July.
Page
Yes,
40.
madam.
Everything, my lord, scheduled, my lord. It's a complaint case, my lord.
Complaint case. Hired Mr. B. Borua, landed counsel for the petition. The present criminal petition under section 48 or 528 B and SS is preferred, seeking quashing of criminal proceedings of complaint case number
16C. my lord.
16C/2024, presently pending in the Court of Judicial Magistrates, First Class, Dibrugarh, Trial Court, wherein the 2 petitioners herein have been arraigned as accused. Full stop. Para, in the complaint, comma, the respondent number 2 dash complainant has inter alia alleged. Where is the cognizance order?
Someone I have annexed, but page 27.
Page
27, my lord.
has inter alia. When this BNSS came into force?
Lord, 20.
So, this is not order taking cognizance, this is summons.
Yes, upon and I appeared, page 35. my lord. 35, we appear.
You appeared also?
My lord, because of the summon, my lord.
Okay, but that ground is not taken. The complaint has inter alia alleged commission of offences under sections 418, 420, 423, 427, and 506 of the Indian Penal Code, post of the learned trial code, the trial code, taking cognizance of those offences, should process against the petitioners for their appearance to stand in the trial, post of para, Mr. Borwal and Council for the Pit has referred to the an agreement for sale executed between the petition number 1 and the respondent number 2 on 1/2/2023, and the events subsequent thereto, resulting in cancellation of the agreement for sale, post of. It is submitted that on 6/7/2023, the petition number 1 by had refunded the advance consideration by 3 checks to the respondent number 2,
Respondent, sole respondent.
sole respondent, but the respondent on 9/8/2023 returned the 3 checks on the pretext that the respondent number 2 as the plaintiff had already instituted a title suit, TS number, title suit number 95/2023. Before the Court of Civil Judge, Dibrugarh, post of. He has submitted that the return of the checks on 6/7/2023 was prior to the date of institution of the title suit on
19/7, my lord.
19/7/2023. Issue notice returnable on so and so. Steps paid post having regard to the prosecution, it is observed that further proceedings of complaint case number so and so present pending before the so and so remain suspended till the return.
6/2. Obliged, my lord. Deeply obliged.
May please, your lordship.
For 1 minute. Yeah. এইটোৱে ডাঙৰ নালাগে এতিয়া নালাগে এইটো এখন ফাইলটো লগত থৈ দিওঁ পিলা লিখি থৈ দিব লাগিব আমি স্কুলটো
May please, your lordship. Petitioner hearing for paying for recording of NBW issued against the petitioner in session case number 55.
NBWA.
Yes. Your Honor, earlier petitioner approached before your
Take me
lordship.
to the sir, huh?
Earlier petitioner approached before your lordship, and he was granted safeguard and directed to appear before the trial court on 11/11/2025, Your Honor. I have annexed the order, but on that day he failed, Your Honor.
Fail.
And again.
So that shows lack of seriousness.
I have annexed the medical documents, Your Honor.
Huh?
I have annexed them on.
Who has given? Paul.
Oh,
Dr. Paul.
Your Honor,
What medicine he has given? I don't know what is your
as per instruction, he was suffering. from-
gastric medicine or what?
He was
What
suffering.
are the medicines?
He was suffering from diarrhea and vomiting as per the instruction, Your Honor. And he was instructed, he is appointed advocate to file a petition, but rightly the trial court did not accept the petition as NBW was pending against him.
Earlier order, my lord, page 27.
27.
Present petitioner has kidnapped minor daughter. What is the offense? Let us see the FIR first.
I have not annexed the FIR, Your Honor. 366.
What is the charge sheet?
Charge sheet I have annexed.
CGM
At page number 18, Your Honor.
31/8/2020.
It has already amicably settled between the parties, Your Honor. The boy
31/8.
petitioner is supposed to marry that victim girl, Your Honor. She is now above 18 years, Your Honor. So I may be allowed to face the trial.
Prosecution cases and giving house permission marriage. 366.
Session trial করিয়া।
Okay, then what happened? 16 prepared to remain on previous bail.
After filing of charges, I was allowed to remain on previous bail. The case was committed to the
By which order?
case number 23,
23.
16th
They granted bail. Then what happened? This
case was
petition.
committed to the session court, and in that session court, the petition
Subsequent
came here.
Okay, application, union the order.
That
Subsequent order passed by so and so.
Subsequent to order of 11 to 25, the lordship grant me safeguard, Your Honor, but he again failed, Your Honor.
This pose of eleven.
11. Page 27, paragraph 7, my lord.
Now, what is the reason?
Yes, as per instruction, he was suffering diarrhea and vomiting on the.
You were given bed rest.
I may be allowed, I will face the trial, I will appear before the trial court within 3 days, Your Honor. On Monday, I will appear, Your Honor.
Otherwise, taken into custody.
Obligation.
Yes. What is the next date?
Next date 28/1.
28/1. But he will.
15 days. We'll do it in 15 days. Heard Mr. P. New, learned counsel for the petitioner, and Mr. MP. Goswami, learned additional public secretary for the respondent state. Para. On 24/8/2023, comma. The first information report was lodged by one Muhammad Najima Khatun before the officer in charge, Sotia Police Station, alleging inter alia that on 23/8/2023, comma, the petitioner kidnapped the informant's 16 years daughter by giving her false promise of marriage. To stop. The FIR was registered as Sotia Police Station, case number 81/2023 on 24/8/2023, and thereafter, comma, investigation ensued. To stop. The investigation resulted in charge sheet number 79/79 on 31/8/2023, wherein the IO reported that the privacy case had been well established against the petitioner for committing the offense under section 366, IPC. Full stop. On submission of the charge sheet, comma, the petitioner appeared before the court of Chief Judicial Magistrate Vishwanath in PRC number 1061/2023, comma, corresponding to Vishwanath Sotia Police Station, case number so and so. Full stop. As the petitioner was already granted bail, he submitted a petition application to allow him to remain on previous bail before the court of CGM Vishwanath. Full stop. The said petition was allowed by the court by an order dated 16/3/2024. Full stop. As the offense under section 366 IPC is exclusively drivable by the Court of Sessions, the case record of PRC number so and so should committed to the Court of Session. Which court? Vishwanath. Court of Sessions Vishwanath, wherein the case has been registered as Sessions case number 55/2024. Full stop. Para. On 30/11/2024, the Court of Sessions finding that after committal of the case, the petitioner did not take any steps on and from 2/4/2024 and order for issuance of non-bailable warrant of arrest against the petitioner, fixing 18/1/2025 as the next date. Full stop. On subsequent dates, order for issuance of warrant of arrest against the petitioner were passed. Full stop. Para. The petitioner preferred a criminal petition under section 528 Bharatiya Nagarik Surakha Sanhita 2023 before this court, agree by issuance of warrant of arrest by order dated 30/11/2024 and the other subsequent orders. Post of the said criminal petition was registered as criminal petition number 1129/2025. Post of this court, on 11/9/2025, disposed of the criminal petition, taking note of the undertaking given by the petitioner to face trial thenceforth regularly and to facilitate his appearance before the trial court on the next date fixed, 11/11/2015. The warrant of arrest issued against the petitioner was directed to remain in abeyance till 11/11/2025. Post of para. The petitioner had again faltered on 11/11/2025 by not appearing before the Court of Sessions Vishwanath. Post of. And the post of the Court of Sessions recording his absence on 11/11/2025, has ordered for issuance of warrant of arrest, fresh warrant of arrest against the petition. Post of. In the above facts of the petitioner is again before this court. The petitioner is before this court again, preferring the present criminal petition and the 528 PNSS. Agreed by the order dated 11/11/2025. Post of para. The petitioner has, the learned counsel, the petitioner has reiterated that he is ready and willing to face the trial henceforth, without any default. Post of. It has been projected that on 10/11/2025, the petitioner suffered What suffering?
vomiting and diarrhea.
Vomiting and suffered from vomiting and diarrhea. And when consulted, the petitioner was advised medical rest. Advised rest. Post of it was due to such reason, the petitioner defaulted to appear before the Court of Sessions Vishwanath on 11/11/2025. Para. You are the only one accused,
Yes.
as the petitioner is the sole accused. The petitioner is the sole accused in Sessions case number 55 of 2024. Full stop. As the petitioner has undertaken to appear in the trial henceforth regularly, without any default on any date hereinafter, this court, in order taking into consideration the interest of expeditious conclusion of the trial, is of the view that for a period of 15 days from today, the warrant of arrest issued against the petitioner by order dated 11/11/2025 can be kept in abeyance to in order to enable the petitioner to appear before the Court of Sessions not within such 15 days without the apprehension of being taken into custody on the strength of the warrant of arrest already issued against him. So it is ordered accordingly to stop the petition shall appear before the Court of Sessions in a period of 15 days from today. So it is further observed that in the event of failure on the part of the petitioner to appear before the Court of Sessions, the warrant of arrest would stand revived, issued against him would stand revived. To stop. It is further observed that if upon his appearance for the Court of Sessions, petitioner files an application for the recall of the warrant of arrest, the Court of Sessions shall consider the same on its own merit and in accordance with.
Item 38.
38.
Please, Your Lord. If the leading counsel, Mr. Ganguly has left for his home for personal difficulty to let him be after vacation.
Okay, on the prayer of Mr.
T. Chetri.
And I counsel for a petition, list the case on suit.
Item 39.
Yes.
My lord, inadvertently, my lord, 482 written, my lord, at page 1, my lord, was.
Okay,
Instead of-
482. You want 528?
to eight.
Okay. That is not a major issue.
But can it be taken after some time, my lord? My senior.
Oh, after
PhD
some time, what?
Sagarika will
I have to rise for a division bench. Other matters are there.
After some time, my senior will come.
Let us see, you take a chance. Yes.
Timing matter, item number 10.
Timing. Yes.
Mr. Lordship, if in this instant matter, may we be allowed to withdraw this instant case?
Miss,
Or assuming on behalf of MK Adas?
it is Bharat Chaudhary.
Bharat Chaudhary.
Yes. Now I remember Bharat
Yes.
Chaudhary.
Yes.
Even after submission of charge sheet and anticipatory bail, application is maintainable,
Maintainable.
right?
Yes.
And Niharika and all says when it's that provision is available, don't invoke 482.
Course of action.
Miss
Oh, Asumi, on behalf
Land
of
Council for the
Congress.
petitioner has submitted, on instruction, that the petitioners want to withdraw the criminal petition with liberty to avail appropriate remedy. Mr. MP Goswami, Land Additional Public Prosecutor for the respondent state, who is present, has submitted that the state has no objection to the state prayer. In view of the above submission made by Ms. So-and-so, Land Council for the petitioners, under criminal petition, is dismissed on withdrawal, with liberty, as prayed for.
Item 15.
You're for 15. Second time, yes, ready.
No, sir.
No, then it has to be adjourned.
Yes.
Vacation. On the prayer, Mr.
S. Chaudhary.
Actually, Land Council for petition lays the case on the data immediately after vacation, first week of January.
Oblige.
For admission, item number 16.
Criminal appeal. You are amicus.
Jail appeal, my lord.
Okay.
Record
hard-
did not come, my lord, and
Huh?
appeal has not
Already admitted or what?
not admitted.
Not, not admitted.
Jail appeal.
Jail appeal. Amicus appointed.
Appointed. Okay, heard Mr. S. Nawaz, Learned Counsel, amicus query for the appellant, and Mr. MP Goswami, Learned
Yes.
Additional Public Prosecutor for the respondent state. Full stop. This appeal from jail. Hmm? Why 497 here? This wrong mentioned.
Convicted under section 370, subsection 3 of IPC.
Trafficking.
Trafficking, my lord. 10 years imprisonment, already in custody for 6 years.
Okay. This appeal from jail, criminal appeal from jail is directed against. So condemnation has been done.
I've only come after this.
Hmm?
I don't think, my lord, there is any condonation. Here,
Ah.
my lord.
No, no IAM.
This judgment was, my lord, dated, no, condonation will not be required, my lord. Judgment was dated 7/8/2024, and this jail petition is dated 18/9/24. So within
Okay.
5.
Against, is
Yeah.
directed against the judgment and order dated 7/8/2024. Passed by the Court of Session Judge Ibahagur, Pal Court, in case number, in sessions case number 27, within bracket, as dash n of 2020, full stop, by the judgment and order dated so and so, the trial court has convicted the accused appellant for the offense under section 370, within bracket 3, Indian Penal Code. And he has been sentenced to undergo
RI for 10 years.
rigorous imprisonment of 10 years and to pay a fine of rupees 10,000 with default stipulation, full stop. The criminal appeal is admitted for hearing. Let TCR be called for. As Mr. Goswami has appeared and accepted notice on behalf of the respondent state, issuance of form is dispensed with. This is the case after 4 weeks. Or
It may be fixed, my lord, because already
note.
more than
report
Yes.
of for a report as regards receipt of TCR.
deep level.
Give a date. Already 6
6
years.
years, my lord. Thank you.
Item 17.
Chandu Chorui Chantal Gugui. A.K. Gupta, sorry. Yes.
But I have the order copy.
What was the issue? Forgot. Ayat avasaniga. I know.
This relates to my lord deposit of 20%.
Case record put up. 1 minute.
Yes, ma'am.
Let me apply with my facts. Enact.
Enact, my lord.
Trial court.
Trial court convicted the petitioner, my lord, against that appeal preferred.
1 minute. This is page 12, right? Trial code of SDGM, Margarita.
Margarita, my lord.
And where is the operative part?
My lord, operative part, lordship may kindly come to page 40, my lord, 40, my lord.
40. So 138 conviction, compensation 15 lakh.
Yes, ma'am. Check
Huh?
amount, yes, my lord.
Further pay compensation as the check amount is 7,70,000. Okay. Then you preferred appeal.
Then appellate.
Where is the appellate court order?
My lord, the appellate court, my lord, first order, lordship will find at, my lord, page 51, my lord.
51.
Here, my lord, the court directed me to deposit 20%, my.
9/1/2023.
Yes, my lord. Then, my lord,
The appellant has not deposited minimum so and so. On this court is a considered and no case of exception for waiver has been made out. So appeal has been preferred as admitted, but petition for suspension of so shall be considered only after deposit of 20,000. Then against this order you have come.
no, my lord, then I have filed one petition by annexing the documents and all this, by saying that this petitioner belongs to below poverty line person, my lord, so he is not in a position to pay so much amount, my lord. That petition was rejected by the order dated, my lord, 14/11/23. That is at page 57, my lord.
Against this order you came.
Yes, my lord. Then this one.
What is the order?
That is a order dated passed by this honorable court, my lord.
20/02/2024. So appeal is of 2023.
Yes, ma'am.
Criminal appeal before the
Before
appellate
the-
court. Submission made pay rupees 50,000 till disposal operation. So remains. Yes, madam, what do you want to say?
My father was a cancer patient, and my lord, huge amount already spent for my further treatment of my father, and he expired. And now, my lord, I am not in a position to survive with my old age and my mother, because, my lord, I have also no source of income. And recent Supreme Court citation, my lord, it's mandatory nature section 145(8), my lord. It's the, my lord, amended section, my lord. Here it says, my lord, the court reaffirmed that section 148 of the negotiable instrument.
Which judgment?
My lord. My lord, Messrs. It was Messrs. R.A. Santana Marketing Service Private Limited versus JMK.
Of which court?
My lord, Supreme Court, my lord.
Ah.
John Benz, 27th August 25, my lord.
Ah.
Here, my lord, 20% deposit amount, my lord, the court reaffirmed that section 148 of the Negotiable Instrument Act creates mandatory obligation for deposit of at least 20% of the compensation amount as a condition for suspension of sentence in appeal cases. It's mandatory. Supreme Court
Yes,
process,
see.
my lord. My I'm also very poor family, becomes a poor
Both are
family.
poor.
Page number 5, my lord. Number 5.
See, who are the parties there? Where from you have taken out this?
My lord, from online,
Ah.
High Court
But this is
library.
not a judgment. Somebody has prepared a synopsis. Huh?
My lord,
Ulakshon.
my lord, now
And see,
I may,
see the check amount. Some 8 crore. Right?
my lord,
And see the parties.
yes,
Tata versus Birla.
yes, my lord.
Here, Mr. X versus Mr. Y.
Yes,
That cannot be because there are other judgments of the Supreme Court.
my lord,
After Surinder Singh, there's Muskan and all. We make it, whether there is provision for.
I'm relying on this judgment.
At what stage? You get the appeal dismissed.
My lord,
yes, my lord,
my lord,
because my lord.
You get the appeal dismissed before the appellate court.
my lord,
Don't waste energy here.
But my lord, 20% amount, my lord, is necessary because
I
my
am making
financial
it
condition
final.
is very poor, my lord, because
I am
my lord,
making it
earlier I
final.
was a sound mind because my father already expired a cancer patient. Huge amount already spent. Now I am not in a position to survive with my old age and mother, my lord. So my humble submission is only 20%.
Now he has furnished document also that he is below poverty line. And both of you are to be taken into, reported to the income tax authorities.
Lordship,
Transacting in cash for more than 2 lakh.
my lord,
And Mr. A.K. Gupta, learned counsel for the petitioner.
My lord,
Mr.
rightly.
Ms. P.V. Bordoloi, learned counsel for the respondent number 1, and Mr. M.P. Gusami, learned additional public prosecutor for the respondent number 2. Yes, Mr. Gusami, what do you want to say? 2 below poverty line, doing transactions for lakhs in cash. Huh. How many lakhs?
One agreement.
Huh.
There it is.
Anyway,
Tax and
this present criminal petition under section 482, read with section 397 stroke 401 Code of Criminal Procedure of 1973 has been preferred for setting aside and quashing of orders, dated 9/1/2023 and dated 14/11/2023, passed by the Court of Additional Sessions Judge within bracket FTC-1, Margarita in criminal appeal number 9 within bracket 4 stroke 2023. Full stop. The respondent number 1 as the complainant had instituted a complaint before the Court of Landed Subdivisional Judicial Magistrate Margarita, alleging commission of Ms. Bordole, for your information, the original judgment is 2-page
My lord.
and your synopsis is 10-page.
Sorry, my lord.
Original judgment is 2-page. Alleging commission of
150 lakhs sold deposit.
Alleging commission of the offense under section 138, Negotiable Instrument Act as amended, full stop. The complaint, in the complaint, it was alleged that the complainant lent a sum of rupees 6,10,000 through 11 number of checks and another sum of rupees 1,60,000 in cash to the petitioner as accused. Full stop. The accused How much the check amount?
Check amount is
Issued a
150.
check
Once,
towards repayment of the borrowed amount. Issued a check for an amount of rupees 7,70,000. From an account, bank account maintained by him towards repayment of the borrowed account. Full stop. The check when presented to dishonored. Full stop. The complainant, after adhering to the procedural formalities, instituted the complaint thereafter. Full stop. The learned trial court found the petitioner accused guilty of the offense under section 138 MA Act and sentenced him to undergo rigorous imprisonment for 1 year and to pay a compensation of rupees 15 lakh. In default of payment of compensation, to undergo simple imprisonment for 6 months. Full stop. Para. Agreed by the order of conviction and sentence, the petitioner preferred an appeal before the Court of Learned Additional Session Judge FTC-1 Margarita, which has been registered as criminal within bracket appeal number 09 within bracket 04/2023. Full stop. The appellate court, while while admitting the appeal for hearing by an order dated 9/11/2023, had also directed the petitioner to deposit %20 of the compensation amount fixing 14/11/2023. The period fixing 14/11/2023 for such deposit. Full stop. When the appeal came up for consideration on 14/11/2023, the appellate court found that no case could be made out by the petitioner for waiver of the deposit of 20% of the compensation amount. Full stop. Before the appellate court, the petitioner took a plea that he belongs to BPL category, but such plea was rejected by the appellate court, taking into account that the petitioner used to do business of betel nuts and was in discharge of his liability, he had issued the check for the sum of rupees 7,70,000 in favor of the complainant. Para, agreed by the order dated 14/11/2023, comma, the instant criminal petition is preferred, seeking a waiver or relaxation of the condition of depositing 20% of the compensation amount. Full stop. This court, while issuing notice to the respondents, comma, on 20/02/2024, comma, directed the petitioner to deposit an amount, a sum of rupees 50,000 before the which court?
For the appellate court, my lord, that is.
Before the appellate court. Full stop. It was further, or it was observed that till disposal of the present petition, comma, the operation of the sentence passed against the petitioner, void judgment and order dated 11/10/2023, passed by the trial court, would remain suspended till disposal of the present petition. Full stop. By order dated 22/2024, comma, the petitioner was also directed to furnish a certified copy of the order that would be passed by the appellate court after deposit of 50,000 before before it. Full stop. But today, comma, Mr. Gupta, Learned Counsel for the petitioner has placed a photocopy of the order dated, of an order dated 29/2024, passed by, court below, trial court,
My lord,
not appellate court.
this on the,
Court below means,
no, my lord, on that day, since the presiding officer was on leave, that's why it was put up before that court. The first paragraph, my lord,
okay,
first paragraph, this record is put up.
wherein it is stated that an amount of rupees, the sum of rupees 50,000 had been deposited by the petitioner before the appellate court. Full stop. The said sum, said amount was directed to be kept in safe custody of the court. Full stop. Para. What BPL? Where is your document?
But my petition is at page 53, my lord, and document page 56, my lord. Type
In
copy,
support of, to buttress the point that the petitioner belongs to the category of, belongs to BPL category. He has annexed a certificate from the Moser, is he a authorized person?
but yes,
I don't think.
it's circle
I
officer.
don't think.
Circle
Circle
officer
officer.
is the authorized person, but he is, my lord, this is village Bisa Gaon. That is in near
Ira
Lekhapani. my
Moja
lord.
Bisagao. Wherein it has been certified that the total annual income of rupees 90,000, the petitioner's total annual income is 90,000. So on the other hand, Ms. Bodolo, Learned Counsel appearing for the respondent number 1 as complainant, has submitted that the petitioner also belongs to
No, my lord, earlier his financial condition was good, but due to the
petitioner's
cancer patient
present financial condition
earlier, my lord.
has also become precarious.
Now, my
Due
lord,
to
at present, my lord,
due to
Cancer
expenditure
patient.
incurred for the
father's cancer, patient,
father's cancer treatment.
all the huge amount of,
Para. As the petitioner has made out has made out a prima facie case for reduction of the deposit amount. And considering the decisions of the Honorable Supreme Court in Khan and Panju kiba ase. This court is of the considered view that the interim order passed earlier on 20/10/2024 can be made absolute pending till the disposal of the appeal, criminal appeal number so and so, comma, presently pending before the court of so and so. It is ordered accordingly. Full stop. Para. The respondent number 1. The respondent number 1 would be at liberty to seek release of the amount of rupees 50,000.
That is already allowed, ma'am.
Already allowed?
Allowed, and he has a withdrawn, ma'am.
Okay, I'm not required. It is expected that the appellate court
Are-
would hear and dispose of the appeal expeditiously.
Already it is fixed for final hearing. 9/12 was the last date.
Only observation.
Yes, ma'am.
Expected.
Obliged.
Item 18.
Jambu, Jambu or Muskan. Jambu. My
18 is also a jail appeal, my lord.
jail appeal sentenced. Okay. First paragraph লিখি দিব, repeat কৰি দিব, আগৰ order. The criminal appeal is admitted for hearing. Let the TCR be called for. Issue notice returnable in 4 weeks. As Mr. Goswami, MP Goswami, লিখি দিব, has appeared and accepted notice on behalf of the respondent state. No formal notice is necessary. Para. In order to represent the appellant, comma, the legal aid counselor লাগিব নে amicus লাগিব এইটো? এইটো legal aid counselor হৈ যাব চাগে। amicus একেইটো list, amicus একেইটো। Oh. Yes, Mr. Goswami, name.
Legal aid counsel.
From the amicus,
Amicus.
single bench, there is another one. Okay.
Yes.
Okay. Mr. Dixit Gogoi, learned counsel from the panel of
Yes.
amicus curiae, be appointed. Stop. The name of Mr. Dixit Gogoi, learned amicus curiae, is to be reflected in the cause list, and he is to be supplied with the necessary documents
Lordship.
by the registry.
May I pray that one set of documents may be served on up because there is nothing.
Okay. Okay. A set of the case papers are to be supplied to Mr. To the learned amicus curiae and the learned additional public prosecutor
Lordship.
by the registry.
Lordship.
Item 19.
In item 16 also kindly, Lordship may kindly observe that. There is also.
Yes.
Item 19, my lord, I'm appearing for the first time, my lord. The amicus, my lord. My lord,
So and so.
appeal may be admitted, my lord.
I will from jail. Heard Mr.
A. Fukan.
Fukan learned amicus curiae for the appellant and Mr. MP Goswami learned additional public prosecutor for the respondent states. A jail appeal, this criminal appeal from jail is directed against a judgment dated 9/6/2025 and an order on sentence dated 13/6/2025. Post up. By the judgment and order on sentence, the accused appellant has been convicted for the judge. Chief Sagar, station case number for the offense under section 304 part 2 IPC, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 with default stipulation. Post up. The appeal is admitted for hearing. Let the TCR be called for. Issue notice returnable on so-and-so as Mr. Goswami he had accepted. Also his set of case paper.
I want a copy of this. Right.
No, only judgment is there, so I have asked
Fine.
necessary case papers to both of you.
9th February, 9 to. Item 20.
Jail appeal, my lord.
Same.
Same, my lord. Here punishment is 7 years and POXO is there, so notice will have to go to the victim.
Oh, as long as amicus for the I go to amicus day and MP Goswami. Response number 1 করে দিব from jail. It was judgment and order of conviction. We don't know that even not, judgment is not available.
Judgment is there.
Only order and sentence.
Sentence there, order is there only. 5/7.
Only order and sentence. Conviction, judgment and order of conviction and sentence passed by the court of learned. Passed by the special court, POXO Sunitpur, Tezpur, in POXO case number 133/2025. Post of the special court has convicted the accused appellant under section 354 IPC and section 10 and section 12 of the POXO Act. Post of the criminal appeal is admitted for hearing. Let TCR be called for. Issue notice returnable on so-and-so as Mr. Goswami, respond number 1, date. Then that as per notification, office to take steps for service of notice. And the respond number 2, that's informant stroke victim. In terms of the notification dated so-and-so. And the office of the public prosecutor is to obtain a report as regards service of notice from the officer in charge of the jurisdictional police station.
Deep level.
To place it to the court as regards.
Registry will take
place. I have said registry office.
Deep level.
Regarding documents, my lord, to ask
Same document.
for taking steps.
Item 21.
This petitioner was convicted under section 326 and 307 for 5 years in both the sections, Lordship.
When?
Lordship, White order dated 34/20/25. And since 17/5/2024, he is in jail and it is more than 1 year, 7 months. So Lordship, conviction is 5 years. IA has been filed for suspension of the sentence.
Heard Miss Ann Chaudhary. Yes, Mr. And Mr. MP Goswami.
Lordship.
And a traditional public prosecutor for the respondent state. Full stop. The present criminal appeal under section 415 PNSS is preferred against a judgment and order dated 34/2025 passed by the Court of Sessions Judge Borpeta Trial Court in Sessions case number 151/2024. So stop. By the judgment and order dated so and so, the trial court has convicted the accused appellant for the offenses under section 326 IPC and section 307 IPC. So stop. For the offense under section 326 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 5 years.
5 years.
And to pay a fine of rupees 3,000. Full stop. Similarly, for the offense under section 307, the accused appellant has been similarly sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 3,000, with same default stipulation. Full stop. The sentences are ordered to run concurrently. Full stop. The criminal appeal is admitted for hearing. Let DCR be called for, issue notice, returnable on so and so, as Mr. Goswami has appeared accepted. No, oh, okay, a copy of the memo of appeal. Sir. Same. Had Miss Ann Chaudhary, learned counsel for the applicant, learned legal aid counsel,
Yes, Lordship.
learned legal aid counsel for the applicant appellant. And Mr. MP Goswami, learned additional public prosecutor for the opposite party, does respond number 1. Full stop. The instant application under section 430 BNSS is preferred by the applicant appellant seeking suspension of the execution of the sentence passed against him and for his release on bail. So stop. The applicant as the appellant has preferred the accompanying criminal appeal. The criminal appeal has already been admitted for hearing. Eyewitness,
Eyewitness, there is no eyewitness, only the victim.
except the victim.
Yes, Lordship.
Public place,
Public place, but there is no one at the time of.
wine shop.
Yes, Lordship.
Quarrel inside the
Quarrel
wine shop or outside the wine shop?
No, outside wine shop.
Outside the wine shop.
Wine shop owner and a shop vendor. 2 persons.
You are owner,
No, I am the shopkeeper.
shopkeeper. Robindra Biswas. We have a wine shop.
I maybe
No.
my lord decided after receiving the TCR, my lord. I
1 year, 7 months
one.
already.
My lord.
By the time you hear the appeal, will be nothing. 1/3 he has already spent.
One third.
No eyewitness.
No eyewitness.
Any improvement?
No, Lordship, there is no. as he is the sole bread earner of his family.
That is not a con. After conviction, those factors have no value. Who is the victim?
Victim is Mithun Sarkar, one Mithun Sarkar.
So both of you are shop owners.
Yes, Lordship, one is wine shop owner and
Where is the injury report? Doctor opinion? Grievous. Grievous.
as per Lordship,
Third, sorry. Ms. Chaudhary Lanet, amicus curiae, sorry, legal aid counsel has submitted that the alleged incident occurred in front of the shops of the applicant appellant and the alleged victim. And there was no eyewitness except the injured. Close up. Para. The applicant appellant was arrested on 17/5/2024, and during the how can it be?
since during trial he
Something is wrong.
during
Where is the order on sentence? Same date.
Case 52.
52, 53.
No, there is something wrong in the sense that come to page 31.
of the eye.
No.
Mean.
Judgment. The accused appellant is undergoing the sentences since 17/5/2024. Gustav. The applicant appellant has already spent a period of more than
1 year, 7 months.
7 months till date. Gustav. Taking into the into consideration the evidence, stroke materials on record, and the fact that the applicant appellant has already spent a period of more than 1 year, 7 months of his 5 years sentence, the applicant appellant has been able to. This court is of the considered view that the applicant appellant has been able to make out a prima facie case for suspension of the execution sentence passed against him and for his release on bail. It is accordingly ordered that pending disposal of the accompanying criminal appeal, the sentence passed against the execution of the sentence passed against the applicant appellant shall remain suspended, and the applicant appellant is allowed to be released on bail subject to deposit of bail bond of rupees 10,000 with one security to the satisfaction of the trial court.
Item 22.
Appeal against conviction of 10 years passed under section 22.
No suspension as on date.
Since 2 years, they are in jail.
10 years is there.
An offense?
NDPS Act, my lord, section 22C.
Then more. It has been diluted under what? Section something. But still rigors of 37 is still there, Supreme Court says. Yes. Heard Mr. S. Biswas Lanet.
36A is diluted somewhere.
Somewhat, but says that
Only-
rigors of 37
will
would
again
still be there
still
to
be there.
see there.
Yes.
And that requires a huge exercise. Same thing as
And also
S.
when-
Biswas Lanet, Legal Aid Counsel for the appellant, Mr. MP Goswami. And additional public prosecutor for the respondent states. This criminal appeal under section 415 Bharatiya Nagarik Surakha Honita 2000 is against a judgment dated 26/2025 and an order on sentence dated 24/6/2025 passed by the Court of Special Judge Kacha Silchar Trial Court in Special Court in NDPS case number 44/2024 full stop. And the accused appellant has been convicted for the offense under section 22 within bracket C of the NDPS Act, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1,000 with default stipulation. Full stop. I have gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. Let TCR be called for, issue notice, returnable on so-and-so.
11-2.
As Mr. Goswami appeared accepted. No formal notice, extra copy of memo appeal within 7 working days from today. Hired Mr. S. Biswas, learned legal aid counsel for the applicant appellant, and Mr. MP Goswami, learned additional public prosecutor for the opposite party, the respondent state. The instant application is prepared seeking suspension of execution of sentence passed against the applicant appellant and for his release in on bail. Post of issue notice returnable on same date. The learned additional public prosecutor shall file objection to instant application on or before the returnable date, if so advised.
11-2.
Much obliged.
Item 23.
Your Lordship. My lord, this is against the order dated 22/9/2022, my lord. Convicted the accused appellant, my lord, under section 10 of POSCO Act, my lord. And my lord, punishment is 5
Okay,
years.
5 years.
Yes, my lord.
5 years.
Yes, my lord. And
Okay.
he has, my lord, behind the jail, my lord, for 3 years, 2 months, 27 days.
3 years?
3 years, 2 months, 27 days. My lord, half of the
Convicted
punishment.
under
Section, my lord, 10, POSCO Act.
Mr.
Then,
3
otherwise,
years.
notice regarding notice.
Notice is mandatory, right?
Mandatory, my lord, POXO, because he has to be hard on every
Hard.
proceeding, my lord.
But my lord,
May not be hard, but put to notice.
my lord.
Yes. Put to notice.
RS Deuri, appellant. You are private
Yes,
counsel,
my lord, private.
learned counsel for the accused appellant, and Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, state of Assam. 415 BNSS.
And I have
Judgment and order dated 22/09/2022. Additional session judge comes special judge POXO Sibsagar, bracket special court. Special within bracket POXO case number 50 of 2021. Convicted for the offense under section 354A IPC and section 323 from IPC, and also under section, sorry. Section 10, POXO, and sentence rigorous imprisonment for 5 years and to pay fine of rupees 5,000 in default of payment of fine, comma, to undergo further rigorous imprisonment for further 3 months. Full stop. The I have gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. Let TCR be called for, issue notice to return everyone so and so. As Mr. Goswami has appeared accepted, no formal notice, memo of appeal. Steps upon respond number 2, in terms of notification number so and so, and alert additional public prosecutor to obtain a report of service as report as regards service of notice upon the respond number 2, that's informant from the officer from the jurisdictional police station. Same thing. Same thing, notice.
Oblige me.
Item 24.
Monju Medi, Nur Islam.
Yeah, please, my lord.
Appeal,
I
criminal appeal.
Yes, my
Against
lord.
what?
Appeal against acquittal, my lord. Under the NI Act, my lord. I am on behalf of the appellant complainant, my lord. The appeal has been preferred under 4194 BNS.
What you are doing here?
My lord, earlier while we have filed the appeal, my lord, there was a provision, optional provisional there, that either we can prefer the appeal before the Honorable High Court or before the Session Court. At that material time,
No.
this judgment, Celestium judgment was not there, my lord. Yes, sir,
When
my
it
lord,
was filed?
Yes, ma'am.
Why you want to lose one forum? When Celestial was rendered?
This was rendered, my lord, 2025 SSC online, 2025, my lord. In 2025, the judgment was delivered, my latest judgment.
Celestial.
Yes, my lord. Celestial. Was delivered, my lord. Really?
Period spent since July 2024
Yes, ma'am.
till date
Yes, ma'am.
can be considered, is to be considered under section 14 of the Limitation Act.
Yes, ma'am.
And law is that statute operates prospectively.
Yes, ma'am.
Judgment operates retrospectively.
Retrospectively.
Provisions were already there.
Yes, ma'am.
It has only been interpreted
Yes, ma'am.
by Celestium.
Yes, ma'am.
So,
In
you
para
go
number
to
7.
appeal before the court, appellate court. Appellate court will be session judge,
Yes,
Kamrup Metro,
Yes, ma'am.
it was decided on 8/4.
8/4/2025. That is judgment. So
Judgment.
it operates.
Applies.
Prospective.
It has interpreted 2WA.
Yes.
Let us see.
A victim
Celestial.
has been included in the NI Act also.
No, victim is not included. Victim has been interpreted
As victim, my lord.
as complainant as well as victim.
Yes,
Yeah.
ma'am.
And a complainant under 138 is also a victim,
Yes, ma'am.
right? So that has been interpreted.
Interpreted in clause number.
Provisions are already there. Right from Celestial tate ase nahi. And this period from the date of filing, the filing or date kuntu hobo 16/7, no? Huh? Till today, limitation ekhon diyo. And this B, heard Mr.
PK Jain, my lord.
PK Jain, learned counsel for the appellant. And Mr. Hey, Justice Thulia eta ase. Justice here.
Apart from the matter, this honorable clause, leave, leave has been granted by this.
Huh? Leave is also not required.
Not required.
Yes.
There are 9
Leave is not.
celestial judgment.
Yes, ma'am. In view of the celestial judgment, leave was not, is waived.
That has been waived.
Yes.
Waived.
Oh.
May I read the, my lord, is what?
No, because of that,
Yes.
not for that,
Yes.
that interpretation where the Supreme Court has said provision operates prospectively,
That-
judgment
yes,
operates
that-
retrospectively.
Yes. That is a, yeah.
To reduce his burden. Can it be tomorrow? Otherwise, I have to rise. Can it be tomorrow, Mr. Jain? Tomorrow, I'll deal with it so that you face no problem before the appellate court.
Can approach to the sessions court.
Section 14 has to be taken care of,
Yes, ma'am.
of the Limitation Act
Yes, ma'am.
and that judgment, so that you face no problem. I'll give you 15 days time to file the appeal before us. এটা কি সিস্টেম? Okay. Tomorrow. Next.
Item 26.
Lisa is tomorrow, huh?
May I please look. This is an appeal against acquittal lordship.
Heard, Mr. Huh?
Appeal against
Appeal?
acquittal lordship.
Same thing.
No, it's not same thing, lordship.
Let us have first the judgment.
Yes, lordship, the chief judicial magistrate lordship,
Ah.
he convicted the respondents lordship. And subsequently the session just reversed the judgment.
Santosh Agarwala.
Yes, I am against the judgment of the session.
You were the complainant.
Yes, lordship.
Okay. And accused, what happened? 11
That was a NIA
2024.
case,
Where is the
lordship.
operative part?
Operative part, lordship will find at page 70, lordship, of the impugned judgment, lordship. That is the sessions court judgment, lordship.
That was a conviction.
There was a conviction by the trial court, lordship, and the appellate court. Page 70, lordship.
Page 7. No, trial court. Please come to the trial court first.
But trial court, lordship, will find that conviction part at 53, lordship.
53. Now, Probation of Offenders Act is made applicable. Convicted company sentenced to pay fine. 1,000, okay. Who were the accused there?
The accused, the
Iran,
respondents herein are the
Yes,
accused, lordship.
Home.
Respondent number 2254.
All were convicted or what?
Yes, lordship.
Huh?
All were convicted.
All were convicted.
Yes.
No.
Hmm?
No.
One expired during the proceeding, lordship.
Okay. And another one has been acquitted,
Yes.
perhaps. Only 2 persons have been.
2 persons have been convicted.
Kanik Sinha. Kanik Sinha, Kanik's case, my lord.
Kanisk, right.
Justice Dhulia and my lord.
There are many, but that
that
name
is-
I remember.
Yes.
Kanisk.
Kanik.
Okay, appeal.
Appeal, lordship, will find the relevant portion, the appeal whereby this trial court judgment was set aside, lordship, page 70, lordship.
Para 70.
Convicted. On what ground?
On ground that the sentence not proper. Sentence. May I read? Look? Learned Court, Trial Court convicted all the accused persons and sentenced them
para?
on different counts. Section 138 of the NI Act provides that a fine for commission of an offence under Section 138 of the NI Act may extend to twice the amount of the check. While the total amount of the check in question is 5 lakhs, the Learned Trial Court has imposed the fine of 17 lakhs. And this sentence exceeds the amount of fine that can be imposed as invaded by Section 138 of the NI Act. Learned Trial Court imposed different fines amount on the accused person. It is not known on what basis different fine amounts is imposed on the partners of the firm. On this count also, the impugned judgment fails to withstand legal.
No, the conviction has been set aside.
Yes.
Huh?
Yes.
So this is sentence.
No, Lordship, the appeal is allowed, the impugned judgment and order pass already. Ought to have been remanded, Lordship, for.
Unclarable person regular depose that he payment of rupees so and so has it. No. Reason is recorded in paragraph 15 and 16. Why the conviction has also been set aside. Okay, heard Mr. M. Ahmed, Learned Counsel for the petitioner. Oh, sorry.
What appeal?
Appellant. This appeal under section 419, within bracket 4. Origin Nagoric Kuruka Honita 2023 is directed against a judgment dated 7/2/2025. Passed by the Court of Additional Sessions at Tinsukia, Assam, in bracket Appellate Court, in criminal appeal number 32 within bracket 4, 2024, whereby the Appellate Court set aside the judgment, a judgment, an order dated 11/9/2024. Set aside a judgment and order of conviction and sentence passed by the Court of Chief Judicial Magistrate Tinsukia in NI case number 143/2018. First the trial court convicted the accused under section 138 Negotiable Instrument Act. Accused at respond number 2 or what?
2, Lordship.
How many?
2, 3, 4, and 5.
No, complaint was by how many?
Again, so
Oh.
complaint I
Let
have
us
annexed.
see.
Lordship.
Let us see your complaint.
Complaint page 17, Lordship.
Okay.
Complaining is
Accused
one.
persons will be portrayed by accused person. The appeal, criminal appeal is admitted for hearing. Let the TCRs be called for. TCR, the small s, be called for. Let the case records of the trial court be called for from the trial court and the appellate court. Issue notice, returnable and so and so.
7-2
Steps. In the state of Assam is party.
Yes, Lord.
MP Goswami, respond number 1.
Item 26.
And 2-2, 2 to?
2 to 5. Lordship.
Why 2 to 5?
Lordship, one died, Lordship, there. One is the
Ah.
company, Lordship. And
Did you prefer any appeal? Or you did not prefer any appeal?
no, Lordship.
Against the conviction or acquittal?
This is the
No. How many were accused?
accused.
Don't
were-
harass.
Accused were 5, Lordship.
Accused were 5,
Hmm.
right?
Hmm.
Company plus 4 individuals,
Yes.
right?
Yes.
One expired,
One
so
expert.
abated,
Abated.
maybe abated.
Hmm.
Then one has been acquitted.
Yes, Lordship.
Then, did you prefer any appeal against acquittal?
No, Lordship.
Then, how you want to harass? By putting him on notice?
Lordship, we had trial court's order, Lordship, 53.
Trial court order, read.
One is the company, Lordship. Then Om Datta, he is sentenced to pay fine, Lordship. Second one. Then Mahesh
Let
Sharma,
us see. Trial court judgment.
53, Lordship. There, the
You took me to 53.
yes. Convicted company MS
Kherem.
Kherem company is sentenced to pay fine of 5 lakhs. Convicts Om Datta Sharma and Sri.
Oh, all 3 were convicted?
Yes, Lordship.
Is it?
Yes.
Okay.
And Mahesh Sharma is only sentenced for imprisonment.
Chalo. 2 to 5. 2 to 5, speed post.
Item 27.
R. Sharma.
NDP.
Yes. Offense?
My lord, under section 21B and 22(9, page 44, my lord.
Page 44.
My lord. I am A3.
Okay. How many?
I am A3, my lord. My lord.
A3.
My lord. 2 convicted, my lord. 1, my lord, died. A1 died. 2 and 3 convicted.
Imran Hussain.
My lord.
Where is the judgment?
My lord, judgments, starts at my lord, page 20.
Hmm.
Order at page 44.
Criminal appeal 415. Special Judge Lakhimpur. Special with Beckett, NDPS case number 10/2022. Conviction. You are A?
3.
3. 21B.
My lord.
Small b.
And 29.
And 29. For the offense under section 21B. 5 years.
5 years.
And a fine of rupees 10,000 with default stipulation. For 29, 3 years, RI, rigorous imprisonment. And fine 5,000 with default stipulation, page 44. The criminal appeal is admitted for hearing. With TCR be called for, issue notice returnable. So, as Mr. Goswami appeared accepted. Same thing, I got to receive notice. Notice. Like item number, what is the earlier number?
Earlier number is
NDPS, S. Biswas. Item number 22, IA, criminal 1353. Same.
Problem.
Yes, Ms. Chaudhary. Legal aid counsel or private counsel?
With Lordship,
Ann Chaudhary.
in this case only notice.
Miss Ann Chaudhary. Who is respondent number 2?
Who is the informant?
Okay. MP Goswami, respondent number 1. Criminal appeal 415. Judgment starts from which page?
Starts from 55.
55. Okay. Additional District and Session Judge Rongia Kamrup. Sessions case number 22/2019. Conviction part
Page 93.
93. $376. Rigorous imprisonment for 10 years.
10 years.
And pay a fine of rupees 5,000 with default stipulation. And for the offense under section 506, 1 year simple imprisonment. The sentences are ordered to run concurrently. I have gone to the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. Let TCR be called for issue notice returnable on so and so. As Mr. Goswami,
Yes.
respond number 1. And steps upon respond number 2 by speed post within 7 working days. I notice.
Obliged. If there is no I.
No, I listed.
Yes,
Oh,
yes.
oh,
I is not listed, man.
oh, something is there.
I we have not filed.
Huh?
We have not filed.
Oh, it's Belagodi.
Delay is there, that was
Okay.
obliged.
May it please your lordship. Lordship, this is an appeal arising out of CR case number 2468 of 2010 against order and judgment dated 8/4/2016. Lordship, it is a check bounce matter. The leave has been allowed on 2/12/2025.
Now leave to. Leave was not required.
Lordship, it's an order against acquittal.
We'll put it tomorrow, same thing.
Lordship, it's a 2016 order and judgment. If
That is why I said Kanisk.
Yes.
That is
Another,
why I said Kanisk.
yes, sir.
I asked him to find out Kanisk.
Yes. Before that also, my Priyanka Srivastava, that citation I have given, my
Priyanka,
Srivastava's case, my there also. That
tomorrow.
case.
Same order will be passed.
obliged.
Let me get 30. Good. 31 would you do? 31 would you? Yes,
May it be pleased, Your Honor.
yes.
Lordship, this is a statutory appeal, Lordship.
Huh?
Statutory appeal, Lordship.
Statutory appeal.
Yes.
Where is
Lordship,
judgment
22C.
page?
Lordship, page 65.
65.
Para
Not
55.
65.
Page 65, Lordship.
Okay. Now,
Para-
where is the front page?
Lordship.
First page of the judgment.
Oh, yes. Look. First page, Lordship, from 32.
32. Okay, Diullah. Appellant, or the appellant. MP Goswami. Respondent. State. Judgment and order dated 27/10/2025. Special, Court of Special Judge within bracket additional Dhubri. Special case number 333, 2023. 22C NDPS Act. Rigorous imprisonment, 10 years. And to pay fine rupees 1 lakh with default stipulation. Admitted for hearing. TCR. issue notice, Goswami. Same as Mr.
Only,
Kishan.
Lordship, my only submission is that a short date may can be fixed because of the fact that none of the Caesar witness, all,
No, we are fixing a date.
No.
Because January, there are many vacations.
of course,
So that
after the
a particular date is fixed.
if possible, Lordship, first week of February, Lordship.
No, it is not possible to manage everything. But in-
Obliged.
Item 31 for orders.
Yes, this for what?
IA for condon.
And Mr.
SS Ahmed, my lord.
S.
SS Ahmed on behalf of
Ahmed,
declarant.
Learned Counsel for the petition, there is an application. Yes, there is a party.
It is a party, my lord.
Ah, what do you say? I do mean. What happened in the trial court?
Your Lordship, the petitioner
Criminal
filed an
revision
application
petition.
to allow him to further cross-examine
Impugn order passed
witnesses.
by the so and so in sessions case number. Impugn order.
Order is at page
Challenging
41.
the order is. So,
Only state is a
oh,
party.
issue notice.
Only state.
Had Mr. So and so and Mr. MP Goswami Learned additional public prosecutor for the opposite party state. This is an application under Section 5 Limitation Act 1963 seeking condonation of delay of 31 days in filing the accompanying criminal revision petition against an order dated 5/8/2025 passed by the Court of Sessions stroke Special Judge Kachar Pilsar in Sessions case number 121/2024 issue notice returnable so and so. As Mr. Goswami has appeared accepted, no formal notice. Please the case on.
Supplementary list, item 40.
May I please, your lordship?
This is for what?
Before the additional CJM court, lordship, case was dismissed for default at the very nascent stage, lordship, before even taking cognizance of the matter, before.
I asked you, but I could not.
Yes.
Yes,
Lordship had asked for the Celestium judgment.
Celestium, then I could collect all the.
Sanjeev Khanna judgment, lordship had given a hint, lordship. But I could collect the judgment of Sanjeev Khanna. However, it is on dismissal of appeal by by the convict. Appeal by the convict, dismissed for default. That is not. I have got that judgment also. However, I have got two other judgments, lordship, which say that when a matter is dismissed for default.
Yes, item number 5, I think today morning, I asked that counsel. The answer is there.
The stage is to be seen, lordship.
That is what?
Yes. In my case, lordship, it was at a very nascent stage, lordship. Someone was not issued. Documents were not exhibited. He had not come into picture. The accused had not even come into picture. So the magistrate had no other alternative than to dismiss the case for default. However, there was no remark that it was dismissed for default and it was acquittal. That has been clarified by the revisional court. Now, revisional court has.
Oh, you went for revision?
Revision also. And revisional court has.
Which revision?
Lordship will take up the IA. IA page 12. Revisional court has dismissed it on the ground of maintainability. Para 10. Para 10. Page 17.
Because I have to sit in a division bench.
Division.
Before 4:30.
Before. Revision page 17 of the IA, lordship. IA for delay. Page 17. Court was of the view that since no section, no provision is mentioned, it is a case of dismissal for default and
So
acquittal
you
under
are seeking
256.
leave.
I am seeking leave.
Let us issue notice thereafter to examine. Had Mr. Dr. T. Sharma, learned legal counsel.
No, lordship.
Learned
Here.
counsel for the applicant and Mr. M. Goswami, MP Goswami. Opposite party one. Issue notice returnable. So.
In-
As
Okay.
Mr. Goswami, he had accepted party number one. Steps upon opposite party number two by registered post. He will use 7 votes.
Lordship, in the
For
leave,
this purpose.
for a moment, Lordship, in the leave petition, there is a delay of 271 days. However, out of the 271 days, 239 days have been spent in the revisional court, Lordship. And 5 days have been spent in collecting the copy.
No, I am not applying my mind right.
Yes, yes, yes.
So this is
It to the river.
13th.
What is 41?
41.
Obliged.
Forty-one,
Please, Lordship. Lordship, this petition is for condoning a delay of 56 days in
Okay.
filing.
Section 5, Limitation Act. 56 days, by any jane na hai?
Lordship,
Issue notice. Returnable so and so. Goswami, opposite party number one. Steps upon opposite party number two by speed post. Within 3 working days.
13-2.
Lordship, pray for a day. For a
13-2.
He is announcing it. Kiman? Yes.
My lord, stately coming to the FIR, my lord, at page 26. This,
You are not there, we put it tomorrow.
my lord, yes. All
Put
right,
it tomorrow. Raise the case tomorrow.
Yes, my lord.
Right?
Yes, my lord.
You are not there,